Yes, I know. Morning, everybody. It's 9:30 and time for the inquiry to resume. I think I'm getting some feedback. Testing again. No, that wasn't. Testing again. Yes. Good. Right. As usual, just an update on documents and where we are on those. First of all, in connection with the bundle of documents relating to Mrs. Hamilton's evidence, the bundle that I was given in hard copy included the one relating to footnote 16, but I don't think I see that on the inquiry documents list. But it's clearly in. I may have missed it, but I don't think it's there. That could just be, that will need adding because I've got it. Core document 232, which is identified as a technical note, that's the document that Mr. Collier spoke to. So I will also be referring to it as Mr. Collier's statement to the inquiry. A note came in which I think Mr. Kernan had referred to in evidence concerning agricultural land classification statistics, and he gives them for the country, for Hertfordshire and for the district. My understanding is that those are historic figures relating to 1977. I just wanted to check that I have got the right understanding of that.
Yes, that's right.
Yeah. Got Mr. Harding's response to the note on flood risk and highways in the form of an email, which I know has been copied to the other main parties. The revised site visit itinerary, I'd like that including as an inquiry document, please. I've got version 4 of the biodiversity table. Now, there was some discussion about the technical difficulties of putting this on the inquiry website. I will be listing it as an inquiry document. So the documents that came in since the inquiry opened, they'll be in a list at the end of the report. So that will be included there. I don't know if it's possible to either deal with the technical problems or include it in at least some modified form as on the council's website, because I would like the list of inquiry documents there, if at all possible, to be compatible with the list that will be appended to my report.
As I understand it from the council, I don't think it's possible to host it to do anything about that. Right. What we could do is we could undertake to print it all off and then submit that to put that into a PDF form. So it'll be a long document.
So the PDF could then go on the
PDF could then go on the website.
Yes.
That sounds fine. My understanding is that it's not possible to put the document in the form it currently exists on the website. In
the form in which I've got it.
Yeah.
But at least the same information can be made available. Yeah. Thank you. And I've got the list of appearances for the applicant that I requested. That won't be an inquiry document. That's just so that I make sure that the appearances list is correct. That's what I've got. in terms of what I think I'm awaiting, and please, when I get to the end of this, add anything you think I may have missed. Ms. Staley, I just for completeness, I asked for documents relating to the minerals plan.
Yes, Mr. Greaves sent it yesterday to Alison Dyson.
Right,
I understand you've been otherwise engaged, so that may not have made its way to you as yet.
Yes, I checked this morning what Ms. Dyson had sent through, that they're not included, but as long as they're on their way, that's fine. And then I think Mr. Hardy, the applicant, was going to deal with the technical glossary that I asked for. Thank you very much.
So as you will see, that is restricted to MVA and MW, so megawatt amperes and megawatts. Now, it seemed to us that those were the crucial two terms that were the focus of discussion the other day. If that is all that's required, then this will do. If there are other terms that you feel it would be helpful for us to explain to the Secretary of State, then of course we can add to that. But I felt that those are the two key matters.
Thank you. Right, I'll have a look at that during the day.
Thank you.
Thanks. And then there was the bundle of photographs that we used on site yesterday, which I know Mr. Collier intended to bring to the inquiry this morning. That's fine if they're in the box. Yes, please. Yes, please, Mr. Collier. If you just pop them perhaps on the desk to my left. Sure. Thank you. And I think, as everybody knows, there's no additional information in there. It's simple that they are hard copies of the documentation that appears in the LVIA and the updates. Just a word about the site visit next. I want to make sure that everybody knows what we actually saw. We had a full day. We kept more or less to the itinerary that had been agreed by the main parties. There were a few diversions. I just want to make sure that you know what else we saw. We diverted from the route on the first part of the site visit to go to the Conduit Head, which took us into an adjacent field to the one that's marked on the route. But we did make a point of, before we went into that other field, of looking down and seeing the field where the route is on the second site visit itinerary. We took in a few extra viewpoints which Jog wanted us to see from Gravely Road within the conservation area, looking towards the application site. And at Milksey Cottage, I was invited inside, and we viewed we looked towards the site and the surrounding area from 2 first-floor rooms. Subsequently went to Gravely Hall Farm, because that was one of the heritage assets that was mentioned by Ms. Roy. And for the same reason, I went to have a look at St. Mary's Church in Little Wymondley. We'd followed the cable route to the substation. At the substation, there was no opportunity for access to it or the local wildlife site, but I've seen its location, I've seen its surroundings and its relationship to them. And finally, I think the last diversion was we went to the location of the photograph that was taken and submitted by Jog, which we'd heard, I think it was clarified at the inquiry, was just outside the OMB. There's also a footpath across the bridge inside the OMB, so we went there just to see what the position was from that site. I just want to check with the main parties that, knowing now where I've been and what I've seen, that they're content with that. And I need to know whether there's anything anywhere else that you would want me to go. Mr. Harding?
No, I think the only other thought I've had, and I sort of referenced it in my closing words, it's the most obvious one of all, and I guess we've all seen it going up and down, but it's from the motorway. It is one of the best points to get a view of the whole place, and I guess we weren't thinking that when our heads, but if any chance you're passing on the motorway as you head north, it is a pertinent view.
Let me give some thoughts to that, Mr. Harding. I don't have transport of my own, so
okay. Right.
Whilst I can do unaccompanied site visits,
I
think it would probably have to be arranged in some way.
Okay. Thank you.
I mean, we've certainly no objection to that. I've been passing it on the kind of pretty much every day.
Yes.
This afternoon, and Mr. Collier would be able to offer a car. I don't know. It wouldn't take very long.
No. Okay. Yeah. Thanks, Mr. Harding.
North and south. I don't know, Mr. Harding. If you went north, can you come off? Is there a junction, and then can you loop round and come?
You just literally go up to the Letchworth Gate junction, the one directly up here. Yeah, so you could leave here, go down south, whip round, go north, and
okay,
5 minutes, 10 minutes.
Right.
Yeah.
Okay. Thanks for the offer, Mr. Collier. Thanks for the suggestion, Mr. Harding. I'll come back after the break on that. Right. In terms of procedure today, we've got the a review of suggested conditions and then closing submissions. In terms of closing submissions, my intention is that they would be in the order shown on the timetable. So, Mr. Harding, you'd be up first. Before we go back to conditions, anything else to raise, Mr. Harding?
Just one matter, and that is an appeal decision, which and it came to my attention yesterday. I've given a copy to the others. It's not a revelatory, but it's a Greenbelt appeal decision. It's a solar array that was granted in the Greenbelt. There are a couple of points if people want to know why I think it's helpful for the Secretary of State to have it, and that's in relation to treatment of openness and this question of temporary and permanent loss. And then also there's some discussion about whether or not it's acceptable to deal with skylark mitigation by way of condition.
Yes.
It is paragraphs 12 and paragraphs 21. It's a decision from, it's called Crays Hall Farm in Essex.
Right. Well, I understand from what you say, Mr. Hardy, but it's only just come to light. And it sounds as though it could well have some relevance, but the other parties would.
I've got no objections.
Well, I suspected that may be the case, Ms. Taylor, but it may not be the case for Jog.
It is a bit late in the day,
yes,
sir, for us to just see what the implications are and build any comment in. I think that would be my observation, really.
I understand that, Mr. Harding. I mean, the approach I have to take really is that all relevant material is available, but equally you've got to have the opportunity to deal with that. So if you would like some time to go through that before you go into your opening submissions, I'm happy to allow you that.
Okay. I'm not sure that I'm really not sure that I'm going to have enough time and focus to alter submissions.
Would you like a few minutes just to check?
Well, we can no, sorry. No, we won't. No, we'll just crack on. Yeah.
Stella, is there anything you wish to raise?
No, thank you. Nothing from me.
Mr. Harding, anything you wish to raise this morning before we start?
No, sir. No.
Okay, thanks. Right, conditions then. And first of all, I just want to check the status. The document I've got is the document that I think was received by the office at the beginning of this week. Yeah, on the 19th. So I think it was prepared by the applicant, but has it been, in the form I've got it, is it agreed by, yes, Ms. Dale, is agreed by the LPA?
Yes, it's agreed by the LPA.
You're just searching for it, Mr. Harding.
I am.
It came with an email. I got mine. You've got it, yeah. Is it agreed by JOG?
Yes, sir. It's agreed by us. There was one or two other additions that we had thought about over time, but I think we're fine to agree it. Yeah.
Thank you. Well, I will check at the end whether there are additional points that you feel should be covered.
Yeah.
So that you have an opportunity to mention those.
So if I can just add to that, we're certainly welcoming if there are improvements, Mr. Harding, and some of the things you said have been absolutely, right to add.
Yes.
like to hear what you suggest, because there may well be things that we agree.
Yes. Just a couple of general points before we go into the document itself. First of all, on this occasion, because it's a report, whatever the recommendation is, there will be a list of conditions, because even if the report has a negative recommendation, the Secretary of State may, of course, take a different view. And so there will be a list of conditions. But my consideration of them and the discussions days on a without prejudice basis.
I think so. One question we were asked was which ones of the conditions would JOG wish to comment on, and I don't know whether you actually, when there's quite a few of them that would be helpful to comment on, but yeah, certainly not all.
You're free to comment on the all, Mr. Harding.
Yeah. Oh, okay. Now that's no, I don't mean now. There was the proposition was made that there was certain things around flood transport.
What further details have to come in?
That we were invited to be a party to the consideration of the conditions when it got to that point in the future.
Yes.
Yeah. So
dealing with further details.
Yeah.
Yes.
So the question we had, do we actually have to try and nominate which particular clauses now we need and want to see, or can we sort that later?
But it doesn't need to be done
today
before the inquiry today, but the council would like you to say which particular conditions you'd like to be consulted on.
Yeah. Okay, that's fine. We can deal with that then outside the inquiry. Okay, thank you.
The other general point I'd like to make concerns pre-commencement conditions, which have to be the subject of agreement by the applicant if they are to be imposed. It's difficult to agree a final form of words in a forum such as this. So, and there isn't, because of the wording of the legislation, there isn't a great deal of scope for alteration. What I would like to suggest for pre-commencement conditions is that where they exist, I'll prepare a draft and send those for agreement of the words, not their imposition, to the applicants, copied to the LPA and JOG for information so that you're fully aware of what's going on. Are you content with that approach? Okay. Now I've only got a few points, so I don't want to go back to ones that have already been discussed at length. But if there are other points, please jump in. The first point I want to raise is on suggested condition number 3. Is there anything before that from anybody? Now, condition 3 is to do with the duration of the solar farm, the 40-year period, and decommissioning at the end. And it may well be unlikely to happen, but it just seemed to me that given the form of words, it would be possible for development to cease if circumstances change, say after 20 years, but decommissioning not to be required until virtually the end of the period, because I think there's reference to 39 years, whereas clearly decommissioning needs to, whatever date this solar farm ceases, decommissioning needs to follow on quite rapidly. And I just wondered if there needed to be a tighter form of words to deal with that eventuality, however unlikely it may seem to be. My thoughts was something along the lines of the land shall be restored no later than X years after decommissioning, in accordance with schemes, and these are the decommissioning scheme and the ecological assessment report, which have previously been approved. But what I'm unsure about is what X should be.
It's possible to put I suppose, a cessation of generation type condition in. Yeah. So what I think, I mean, Jog's point was about, well, look, what if solar goes out of vogue? I don't think that's the point, because the even if there were other types of electricity generation, that this solar scheme is likely to continue. But if there was a cessation of generation, then I can see that bringing forward decommissioning would be welcomed by the Secretary of State. So could we give thought to some wording for that?
Yes, but in the usual way, I'd like it to be canvassed with the,
of course,
with the other two parties. Mr. Harding.
Yeah, I think that is a very sensible suggestion, sir. I think the part of it that particularly concerns Jog is in relation to the batteries and the BESS system, if you like. You've got 100 megawatt system, 22 containers with batteries in. Now, if a solar panel stops being used, it just sits in a field. But the batteries are, of course, quite dangerous if they're not in full maintenance and operation rather than just abandoned. So I think that area particularly needs quite a tight clause around decommissioning once out of use.
Well, I think we'd be more generous than that. To be honest, I'm not sure you'd separate it out. That I think if any part of the development wasn't generated or being used. So I think it would be both parts, Mr. Harding. But we'll, if that's all right, we'll. I don't know how you want us to deal with that. So is it possible to give us a couple of days?
Of course, yes.
And then if we circulate a suggestion, and then submit that to you next week.
Yes, that would be fine.
Because it'll be a bit tight to do it this morning.
Yes, agreed. We've also got just a few points on condition 4. Let me just. Now, condition 4 is the one that requires the submission and approval of a construction management plan to make sure that the actual implementation of the development, putting it on the site, takes place in having due regard to the locality and to avoid inconvenience to local people. The first, it lists, I think, 13 points in all, which have to be taken into account in preparing that plan. The first one of which is confirmation that no development shall take place until archaeological works, the investigation, has been completed. I think that duplicates another condition. I think condition 13.
I put that in because there was concern about tying the SEMP to the to the WSI. I think there was concern that you raised.
There was, yes. You're quite right, Mr. Hardy, originally.
That's the reason it's there, whether or not that
but number 13 now reads, I don't know whether it did originally, no development shall take place until the site investigation has been completed in accordance with the approved WSI. So it seems to me that's fairly clear. The WSI has to take place first before development of the solar arrays on the application site can proceed.
Except that's the site investigation. It's not all the works. So no development should take into the site investigation completed in accordance with the programme.
Well, the site, what other works would there be other than the site investigation, Mr. Hardy? The site investigation includes the trenches.
Yeah. So I mean, these were the conditions, the archaeological conditions I think I mentioned the other day were ones that I'd not tampered with, but there is it's separated out. You see in condition 12, for instance, the development shall take place in accordance with the programme of archaeological works.
Set out in the WSI. So those works relate to the WSI.
Yes. But my point being that there appeared to be a difference, a teasing out of archaeological works and site investigation. So I mean, rightly or wrongly, I had assumed, given that separation in terminology, that works may be something different, and therefore, out of as a coverall in the SEMP, had made plain that all works, everything had to be done. But if you feel that's duplication, then it could be something timetabling. Well, either it comes out completely or just timetabling, including confirmation that the WSI has been.
As far as the applicant's concerned, Mr. Hardy, do you think there are additional works to what would be embraced by the WSI?
No, I think it's all in the WSI.
Yeah, that's what I had thought. Mr. Robinson, what's your thought?
I agree that for the sake of simplicity and potentially to reduce the number of conditions, that it's possible to amalgamate the two. I think as the direction that you've prompted with your comments.
Mr. Harding, what do you think?
I think as long as it doesn't diminish the responsibilities and works on the archaeology, that would be acceptable.
Okay, thanks. I'll bear in mind carefully what Mr. Hardy said. I mean, it is imperative, I think, from what I've heard, that the archaeological work proceeds first. So I want to make sure that any condition does satisfactorily cover that. I'm just going back to condition 4. Just a small point concerned with the form of wording. I'm not entirely happy with the detailed wording of the second part of condition 4, which includes the phrase shall have due consideration. Certain tests that conditions have to fulfill, one of which is they've got to be precise. I'm not sure that that form of words meets that test, but that's something I'll give consideration to. And my other thought was about 13. Something that we've discussed, but this is to do with installation of the underground cables along the route to the substation. And it's requiring confirmation that no spoil or material shall be stored adjacent to Stevenage Road or along Priory Lane where there's a risk of surface water flooding. I just felt that perhaps that should be, it should clear, I think it should clearly be there, but I wondered if it should be a separate condition rather than included there.
Well, so I included that in condition 4.
Yes.
13.
Yes, I know.
Oh, when you said condition 13, do you mean?
No, not condition 13. It's
you
part
mean
13.
Part 13 of condition 4?
Yes.
I don't mind.
Yeah. I think that would give added emphasis to it. And I'm not really sure that the construction management plan should just be confirming other things. I think this is something that's a requirement in its own right.
So it could be a positive, but no spoiler material shall be stored adjacent.
Yes. I think just a final point. I think it was a point that may have been raised by Jog when we had the first discussion on this. And they made the point, I think, that some of the works involved relating to the WSI, in particular the trenching, might themselves, they're fairly extensive, go across a large part of the site. And I think the suggestion was that they themselves could be liable to perhaps have implications of noise and dust in the vicinity, and that perhaps some of the measures that are included in 4 should relate to WSI works as well, rather than just the subsequent operational development. And I just wondered if there's a way of perhaps identifying those.
So 4.2.
Yes.
Control and management of noise and dust. It could be during the works included in the WSI and the construction phase.
Yes.
I think just as in terms of being comprehensive, whenever you've got reference to a British standard, it also have a successor document attached to it as well, just in case the standard changes.
Yes. Number 7, for example, could also affect the relevance of the WSI works, the harm to biodiversity features, given what we've heard about the site.
Yes, so we can add in just an express reference to WSI works in the approved WSI.
Yes. You're happy with that, Mr. Harding? Yeah. Does that address your concern, Mr. Harding?
Yes, that's fine, because as you say, they are extensive, so that's good. Yeah.
Okay. Now my next note, I think, relates to condition number 11. So is there anything before we get there from anybody? Condition 11 is the first of the archaeology conditions. And the first part of that, again, it's got several parts to it. The first one says the programme and methodology of site investigation and recording. That's a requirement. That's got to be set out in in a scheme, including ensuring that the areas identified in the submitted WSI as no-dig remain as no-dig areas. Now, my thought was that, again, partly for emphasis, was that no-dig should be a separate condition in its own right, simply a stipulation that no-dig areas should be no-dig areas rather than being subsumed in a separate condition. But is the way it's worded like this, Mr. Hardy, because there's a possibility that the no-dig areas may vary from what we've seen so far on the plans, because it refers to the areas identified in the submitted WSI.
Well, I think the specificity they're not going to change in substance, but the absolute details. I wouldn't want to tie that to a plan at the moment. So I think those no-dig areas would be identified in the WSI.
Yes, yeah, because a revised one is proposed.
Yes. So they're going to be in the same broad area, but the actual precise limitation might change.
Irrespective of that, what about the point of dealing with it as a separate condition?
Difficulty with that at all. It's the same restriction, just a matter of emphasis. So
yes. Okay. Mr. Harding?
I think that covers it. I'm just trying to think through the logic of this, because if when the trench work is going on, I think, as I understood the idea, was that if you take some layer of earth off and you go down and you find something, then you cover it back up quickly, and then that actually becomes another no-dig area, presumably, and we'll have to have different treatment by way of the beams rather than the posts. I think that was the principle that was being explained. So I don't know whether that amends anything that one would need to say here about additional no-dig areas that might become apparent.
I think there was a suggestion that there may be ongoing revision. I think that was something that Mr. Roy touched on. I think certainly things were found. I think one of the things that would happen was there would be recording of what the position was, and I think that's covered. Let me just have a look at the parts.
Yeah, it's just presumably if something is found, the point is it wouldn't end up a post put through it. Is that right, or do I misunderstand that?
Let me just. I mean, the point you raised, Mr. Harding, may be covered by part 2 of the condition, which talks about the programme for post-investigation assessment and exactly what that would involve. I certainly recollect the suggestion that there may be that this is an iterative process, in effect, that you don't know exactly what is going to be there before you do the trenches. That's the whole point of doing them. So there may be changes, but yeah, I'll give some thoughts whether that needs just to be clarified. Thank you. And condition 12, which is just requirement for development to proceed in accordance with that programme of archaeological works, that could equally well be part of the previous condition. It's just a.
I mean, it felt to me as though 11, 12 and 13 could be one condition.
So that,
but as I said, they were an agreed position that I was presented with, so I didn't meddle with them.
Yeah, okay. Just a couple of other points. There was a suggestion the other day. We received the consultation response from Hertfordshire on archaeology, which refers to a number of conditions within it. I think there are 3 suggestions from them. 2 I think are picked up on the list. They refer to biodiversity net gain, and there's reference to that in the list of suggested conditions. They refer to a soil management plan, the cable route. Again, that's picked up. And then they have a suggestion at the top of the second page, which says to secure the maintenance of hare and breeding bird populations, recommend a condition to ensure the production and implementation of a suitable monitoring strategy. I don't think there's anything that quite picks that up. But I did wonder whether condition 6, which is the landscape and ecological management plan, and I think the way it's worded, a lot of it's aimed at
8. So it's that is part or subparagraph 8.
Monitoring and remedial measures.
Yes.
Yes, in general. Yes, you're right. But a lot of the condition is focused at habitats. There's a reference to species in part 9.
Yeah. If you wanted to make it more.
Well, I just wondered, given the wording of the ecological assessment report, which we heard about the other day, which does give some indications of measures that should be undertaken. For example, in response to concern about the movement of wildlife, there's the provision, I think, for access at the bottom of fences for certain species to come through, and that's a suggestion. I just wondered whether one of the points should be that the management plan should include measures to safeguard wildlife in accordance with the EAR. So it should be prepared, taking that into account.
Yes.
Yeah. Mr. Robinson, you're happy with that?
Yeah.
Yeah. Thank you, Mr. Harding. I've got nothing else that I want to raise on suggested conditions. Mr. Harding, have you?
Thank you.
Councillor, Mr. Harding. And
no, I think that's fine, sir. Thank you.
Okay, thank you.
I mean, in terms of those amendments, there's the cessation of generation condition, which we'll have a look at. Those other changes, shall we or shall I have a go at building those in to at least move it on? I mean, pretty much there, but move it on a little bit further, or do you want me to just confine my effort to a cessation of generation condition and leave the rest to?
I think at this stage, Mr. Hard, if you just restrict yourself to number 3,
to the cessation of generation.
Yeah, I think I've got the measure of the responses from the parties, and I'll deal with them.
Thank you.
So so I'll expect something on that one by the end of the next week was a suggestion, but obviously it's got to go around all the parties. I think
it'll take, I mean, look, if it's just that, then by the end of next week, definitely, but I'd probably be sooner.
Yeah. Okay, Mr. Harding, with that timescale. Yeah, good. Right, that's conditions then. So it's moving on to closing submissions. Mr. Harding, you're first, and I think somebody. Yeah, oops. Yes. Mr. Harding, as I mentioned earlier, is it possible to send a Word copy into the office?
Yes.
To Alison Dyson.
Yes, sure.
Yeah. Thank you. When you're ready then, Mr. Harding, please, if you could just read it out.
So I'm just Right. Well, good morning, sir, and everyone else. And yeah, I was very pleased your major walk you reported on went well yesterday, and you kept dry most of it as well. Anyway, we reached the last day of the inquiry, and near the point we pass on the baton to you, sir, to make your recommendations to the Secretary of State. But before I sum up the views of the Joint Objectors Group, I would like to just offer some thanks. Firstly, to you, sir, for affording us the opportunity to take a full part in this inquiry as a Rule 6 party, and particularly for your fairness and tolerance, as well as the razor-sharp eye for detail that you have brought to the facts and evidence. I'd also like to thank your case officer, Alison Dyson, for her administration, and Isabel Stones from CMS for her sterling work in maintaining such a usable and accessible database for all the parties. I'd also like to thank Ms. Daly and Mr. Hardy for their tolerance, most of the time anyway, as we have found our way through the procedural maze. And also, finally, to all those who have supported me in the role that I've found myself playing, our expert witness, Jed Griffiths, our other speakers, Liz Hamilton, Jess Simpson, and David Jackson. Behind the scenes, many have contributed greatly, but with particular thanks to Derek and Cherry Carter and Paul and Diane Kennedy. Finally, to all those in our parish and beyond who have taken an active interest by attendance and watching online. Cheyenne, I think, is the furthest I'm aware of. What will we all do next week? So I would start then just by reiterating our stance throughout. The Joint Objectors Group represents local people and strongly oppose this application for the reasons outlined at the start of the inquiry, being the sheer scale of the solar array, its location in Greenbelt, loss of openness and setting, the use of the BMV agricultural land, and the close proximity to exceptional heritage assets, all leading to severe impacts and harm to the local community. We've heard 2 weeks of evidence, and there are large numbers of boxes of documents, but ultimately this inquiry comes down to some very core principles. Some we are agreed upon, others clearly not. No one is disputing harm to the Greenbelt and degree of harm to landscaping and openness. Other harms have differing views, as does the question of whether the proposals meet the key test and whether the very high bar of very special circumstances have been demonstrated. Well, AGR's team believe that they have, the council believe they have, but with a more balanced view, and we consider that the balance remains against the very special circumstances for the reasons that our witnesses have outlined and which I will summarise. So if I start, sir, with the Greenbelt, we are all agreed that the proposed development is inappropriate in the Greenbelt, as set out in paragraph 147 of the NPPF. A solar array is not one of the exceptions listed in 149 of the framework. The applications should not be approved unless very special purposes exist. And in paragraph 148, we are reminded that very special circumstances will not exist unless the potential harm to the Greenbelt and other harm resulting in the proposal is clearly outweighed by other considerations. JOG believe that the proposed development would result in substantial harm to the Greenbelt, which in the planning balance clearly outweighs the need for a solar array in this particular location. There are a range of other harms too, which I will refer to in my statement. As I explained in my opening statement, JOG is not opposed to renewable forms of energy, but the sheer size and scale of this proposal is not appropriate in this location. Ms. Daly for the District Council advised you that the adopted local plan had provided for a net increase in Greenbelt of around 40%. This has resulted in additional area of Greenbelt to the west. In this inquiry, however, we are concerned with this particular development on this particular piece of Greenbelt. The planning witness at this inquiry referred to the essential characteristics of Greenbelt, which are their openness and their permanence. On the question of openness, there has been reference to the case of Samuel Smith Old Brewery, Tadcaster versus North York's County Council. Two aspects of openness were considered, the visual and the spatial. It was determined that the visual quality of the landscape was not in itself an essential part of openness. From this judgment and others, it is clear that visual impact was a matter of planning judgment and common sense. In the case before you, sir, JOG maintains that the visual impact of the proposed development would be considerable, given the open nature of the site. We trust that you will have seen this on your site visit yesterday. The spatial aspect of openness has been defined as an absence of built environment, built development. In this case, it is clear that the bulk of the site would be covered by the solar panels and associated infrastructure. During my questions to Mr. Hoyle, he agreed that the application was development as defined by Town and Country Planning Act 1990. As described by Mr. Griffiths in his evidence, the openness of the Greenbelt would be severely compromised by the solar panels, fencing, transformers, buildings, and other bulky and unsightly equipment associated with the proposals. It would create an industrial landscape. I trust that you will have appreciated that point on your site visit yesterday. The planning witnesses have considered the impact of the proposed development against the 5 purposes of the Greenbelt, as set out in paragraph 138 of the NPPF. In his evidence, Mr. Griffiths provided you with a description of the evolution of the Greenbelt in Hertfordshire and how its boundaries were determined. An understanding of this context, we believe, is vital to the determination of this application. As Mr. Griffiths explained, the site lies within the London Metropolitan Greenbelt. Hence, purpose 1 is to check the outward sprawl of Greater London into Hertfordshire. And to illustrate that, recall that Mr. Griffiths produced the Cloring hand map. In exchanges with Mr. Robinson and Mr. Hoyle, it seemed to be agreed that there would be some impact on this purpose, but not beyond the generality of its application to all parts of the county. The key issue then was the potential harm of the proposed development to Greenbelt purposes 2 and 3. Turning to the first of these, there was a difference of view between the council and the applicant on the potential impact on preventing the neighbouring towns from merging into one another. In his proof, Mr. Hoyle swiftly concludes that the proposed development accords with the first 2 purposes. By contrast, Mr. Robinson had a more considered view in his evidence, where he stated there would be limited adverse effect. JOG disagree fundamentally with these views. In my opening address, I referred to an extract from the North Herts local plan proposals map, which was also appended by Mr. Griffiths to his proof. On this page was superimposed the application site, the Wymley substation, housing areas allocated in the local plan. The map showed very clearly the open gaps between Stevenage, Hitchin and Letchworth, which the policy seeks to protect. The gap between Stevenage contains the excluded village of Little Wymley, with an allocation of 312 dwellings, as shown in the local plan. To the north, there is a wider gap towards Letchworth, but as we have shown, the sheer size of the proposed development would fill about 1/3 of this gap. It is our view that there would be a significant adverse effect on purpose 2. Turning to the third purpose, JOG appears to concur with the view of Mr. Robinson in his proof that there would be significant harm in terms of encroachment on the countryside. By contrast, Mr. Hoyle stated that the harm would be limited, referring to the A1M and urbanising factors. JOG rejects that portrayal. The motorway is a legitimate use of land within the Greenbelt. As Mr. Robinson and Mr. Griffiths have pointed out, there would clearly be encroachment on the countryside because the site consists of open fields. Again, this would have been very clear from your site visit. Both Mr. Griffiths and Mr. Robinson referred to the North Herts Greenbelt Review of 2016, which was updated in 2018. It was agreed that the application site was divided between subparcels 10B and 14F of the Greenbelt assessment. The results of the assessment confirm that both of these parcels made a significant contribution to Greenbelt purposes. This reinforces JOG's view that the proposed development would make a fundamental difference to the integrity of the Greenbelt in this part of North Hertfordshire. I now just turn attention to the issue of temporary or permanence. One factor that seems to impact people's views is whether the construction should be deemed permanent. JOG's view is that its length of 40 years and degree of scale of construction makes it indeed permanent. And this point has been acknowledged in a number of recent inspector decisions, including, for example, Landed East Pelham Manuden, where the inspector stated this would be highly contrasting industrial infrastructure that would be present for an extended period of around 40 years. The extended chronological span, together with together with the scale and size of the proposal, would be perceived as permanent rather than temporary features within the landscape. And note, this site is actually smaller than ours. And also Mr. Gareth Thomas stated in his refusal of the Swadlincote application in Derbyshire, it appears to me, as it has to other inspectors at appeals cited by the council, that 40 years would indeed constitute a generational change. It does seem to JOG that a fair description is indeed perceived permanence, given that generational period of change and time. So if I may, I'll now move on to the site locational evidence that we've heard. After the planning evidence presented by Mr. Hoyle, it became clear that many questions remained unanswered from the applicant in respect to the original scheme of investigation. Mr. Collier therefore produced a paper and gave it evidence. He explained the process that AGR follow in establishing potential sites and explains the importance of the network connection and the limited options available to them given their search criteria. He particularly outlined the criteria AGR adopt as being checking network capacity, a 4 kilometre maximum radius from a substation, low curtailment areas, capacity that they were seeking of 49.995 megawatt output, 400 metres from homes, no major obstacles to complicate the cable run, landowner willingness to negotiate, and ideally single ownership, and transmission agreement. Now, this clearly sets out a number of limiting factors reducing choice, though it does not interestingly show any early analysis of matters such as greenbelt status, agricultural land, quality, heritage assets, community, openness, or visibility. The first search, according to the applicant, focused them down to one primary site with one or two secondary possibilities. Whilst following a certain logic, what is wrong with the process that brings so many limited outcomes? Firstly, to JOG, it seems that too many core criteria were adopted, limiting the search, for example, by size of output, results meaning needed capacity and land size had to be found. The 4 kilometre restriction reduces options based upon financial aspects that we're not a party to
and cannot therefore reasonably take account of. We seem to understand that some schemes can go into the network via an existing cable route, such as Swadlincote, quoted yesterday, and then transfer longer distances to the substation. The search criteria did not seem to show any sensitivity to such matters of BMV, agricultural land, greenbelt, openness, heritage, etc. If it had, maybe a solution on a smaller scale, more appropriate for the site and surroundings, may have been selected. Trying to shoehorn such a monster scheme into a small and important greenbelt area has caused the scheme to face many challenges that have made it unacceptable to the adjoining communities. Indeed, it also starts to fail on its original avowed criteria, such as the distance from properties, in this case, Milksea Cottages. JOG is also concerned with a site allocation of some 88 hectares. We, from the outset, as Mr. Collier will know, questioned the scale of land required to provide the 49.995 megawatt output, as it is far greater than many other locations. We've been told that the panels being used are the most economically viable for the profitability of the project as a whole, but no evidence on this has, however, been provided, and the council sought no data. We do understand that as technology advances and develops at a pace, solar installations are becoming so much more efficient. For example, bifacial panels, we understand, cost 10% more, but are 20% more efficient. Could that have reduced the land used by 20%? North Herts have two other applications in process at the moment, one within the parish known as Spurbury Hill, which is 25 megawatt and 35 hectares, and another at Bygrave, where it is assessed access to a local substation with 53 hectares producing 40 megawatts. It is possibly pertinent to compare scale on a megawatt per hectare basis. Why can both the other applications achieve 0.7 and 0.75 megawatts per hectare, but this application only achieves 0.56 megawatts per hectare? When scale and adjacency to the conservation area are a major concern, it is frustrating to see such a divergence between the sites. Is this due to layout, quality of panels, or other factors we just don't know? All this uncertainty and factors outside of the planning system brings into question what basis is it reasonable to consider the application, as the facts outside our control are the ones the applicant argues brings about the very special circumstances. This was disputed in the case of the appeal by Sawston Solar Farm Limited, where the inspector concluded that the connection to the national grid is an essential requirement, and the availability of a connection is in the part of the network with capacity to accept the output is of assistance to the applicant, but it does not bring a public benefit and adds no weight to the planning case for the proposals. The issue of relevance was also picked up by the inspector in the Manuden case. Whilst an alternative site assessment has been submitted, this is limited by the reliance on an unsubstantiated distance of 4 kilometre point of connection with the electricity grid. So from the evidence provided by Mr. Hoyle, it seems also that a robust brownfield investigation was not undertaken. Indeed, the council's brownfield register was, it appears, not even reviewed. Nor was rooftop solar given any serious consideration, even though it is becoming an ever increasingly important part of the solar industry. It also appeared from evidence from Mr. Hoyle and Mr. Kernan that no soil studies were undertaken on any other sites, indicating an indifference to the importance of the BMV land in the equation. By referencing the appeal decision on Swadlincote, CD 188, the inspector in that case stated No soil survey work was completed other than the appeal site. This factor is a significant omission. These conclusions emphasize to me that the applicant's criteria and the National Grid network should not be the overarching criteria that trumps all others. Otherwise, every application would be approved, and it is certainly not. Renewable energy generation is an important criteria that rightly should carry weight as we aim to achieve our net zero target of 2050. It should not, however, ride roughshod over everything else, and it must follow a rigorous path of investigation, which it does seem was only partially undertaken in this case. I move on now to development plans. The development plans were addressed by all three planning experts. Reference was made to the local plan adopted November 22, as well as the Wymley Neighbourhood Plan adopted in 2018. It was accepted that the plans all reference the guidance within the NPPF, particularly example paragraph 461 of the local plan, stating that proposals for future development within the Greenbelt will be considered against national policy. This policy states that the council will only permit development proposals in the Greenbelt where they would not result in inappropriate development or where the very special circumstances exist. The bar to achieve very special circumstances being set very high. It is common ground that the development is inappropriate development. In the neighbourhood plan is an important document put together by the Wymley Parish Council Neighbourhood Plan Group. This document was compiled diligently by local people with reference constantly back to the local community. The Greenbelt message is reinforced by reference to this neighbourhood plan, as when consulted, the parish survey, 92% of respondents identified Greenbelt issues as their primary concern, as I read out in my opening statement. The one overriding matter when considering the local plan was that we find ourselves here embroiled in a major application that has no reference point in a relevant plan. NHDC are in the process of considering 3 solar arrays. This one, another partially in our parish at Spurbury Hill, Redcoats, and one in Bygrave, 7 miles away. Any one or all of these would make a major impact on the whole of North Herts, how it is perceived, how it is enjoyed, and people's desire to live here. The impact of this application, when viewed from the A1M, will probably be the biggest, most in-your-face solar array between London and Edinburgh, with some 30 million car movements a year. North Herts will be defined by it. Maybe some would say good, but my point is that it is without a thought through consulted plan. Surely that cannot be right. The council chose to declare a climate emergency with a view to achieving net zero by 2040. Is it right that that should be the driver rather than the government's overriding plan to target 2050? There is time for a proper plan review with consultation and careful reviewed options, and no need to knee-jerk react to every application. I now move on to landscape character. It was acknowledged by all parties that the proposed development would have an impact on the landscape and its character. The council's committee report described the effect as moderate in the light of the applicant's landscape and visual impact assessment. And the peer review by the Landscape Partnership, in his evidence, Mr. Mason described how the harm to the landscape would be mitigated by planting measures, which would conceal the site from public view, especially in year 10 and beyond. Nevertheless, it is clear that the site could not be screened completely. It is very open in nature, as you will have ascertained from your site visit. Both the applicant and the council have pointed out this is not a valued landscape in terms of planning policy. As Mr. Griffiths stated in his cross-examination, it is important in terms of the local landscape character and contributes to the intrinsic value of the countryside. Both Mr. Griffiths and Mr. Robinson referred to the North Herts Landscape Study of 2011, produced by the Landscape Partnership, in which the application site was part of the Arlesey Great Wymley Landscape Character Area. Although the LCA as a whole was described as having a low moderate sensitivity, it is significant that historic settlement of Great Wymley is cited as a prominent feature of the historic landscape pattern. It is also stated that the expansive views from higher ground create a sense of space and openness. With regard to the application site, these characteristics can clearly be seen in the photographs provided in support of our case. In our view, the Greenbelt, the site is an essential part of the setting of Great Wymley, which is washed over by the Green Belt. The proposed development is surely contrary to local plan policy NE2, which seeks to avoid unacceptable harm to landscape character and appearance. We say that the insertion of a solar array of 88 hectares is surely unacceptable in that context. We've also argued that the proposed development would be contrary to policy NE3, which seeks to protect the Chilterns area of outstanding natural beauty and its setting. You will have been able to judge whether this should be given any weight following your site visits yesterday. Whatever your conclusions, maybe the views that you will have seen and the photographs produced by Mr. Mason will be testament to the success of the policies of the AONB, the Greenbelt, and countryside protection. These have produced the lasting images of a living and working rural landscape, of which agriculture is a key component. I now move on to heritage and archaeology. We presented evidence via a local resident with a lifelong interest and educational background in archaeology and the maintaining and restoring of heritage assets. Mr. Jackson took us through the history of the Wymondleys, emphasising the very long and exceptionally preserved history in the village and its link to a landscape over 2,000 years. In particular, the field systems showed glimpses of Roman occupation right through to the medieval, emphasised by Seabourn in his landmark research on the origins of the English village. This 19th century work also brought historian Professor Michael Wood to our village, who concluded in his book, Searching for the Roots of England, the finds in Great Wymley open up one of the most intriguing and difficult questions, perhaps the single most important question in British history. How much of the Celtic and Roman past went into the Anglo-Saxon culture and identity? The assertion was underlined when he visited the village and spoke at a dinner held at the barn at the Priory that you visited yesterday, sir. Mr. Jackson went on to set out the history of the village and particularly its setting in a landscape which evolved from the earliest prehistoric agriculture. It is also known that Roman remains indicating a Romano-British settlement or outbuildings of a villa were discovered when the council houses were being built in the 1930s. And further digs have been undertaken in the last couple of years relating to a house extension that revealed more finds on the site. The importance of the Roman road near to Gravely heading north-south points to an obvious trade route which would have had people attracted to it. Hence, it is not surprising that sites 2 and 3 on the GeoFIS point to a possible ladder settlement. Great Wymley was important as a crossroads, with farming estates in Anglo-Saxon times and its ownership by either clergy, Anglo-Saxon kings, and even passed on to William the Conqueror. By the Domesday in 1086, the land of Great Wymley consisted of over 1,500 acres, encompassing all the land between the village and the historic Great North Road, which itself was Roman or earlier. The Augustine Priory, built close to the spring, which had a Victorian pumping house put on it, was probably always important as a source of spring water. Water was so important for livestock and humans. There was a whole priory economy built around that valuable freshwater supply. The link in the latter medieval landscape continues on with the Motte and Bailey fortress erected during King Stephen's reign. Not surprisingly, the Roman, early medieval, Norman, Plantagenet and Tudors are all now starting to crowd on top of each other. Joining all these pieces together is this complex jigsaw singles Great Wymley and the Wymans as being exceptional in their richness of heritage. The conservation area in part marks this out, but does not recognise the village's inexorable links to the lands around it. The fact that the developers' GeoFIS surveys has shown up some very interesting and substantive indications of past human occupation over thousands of years does not surprise us. The ground hits at site 1, not far from the Roman cemetery, could be prehistoric, Bronze Age, or a Roman farmhouse linked to a Roman settlement at Great Wymley. Ms. Roy gave evidence not disputing the broad principle of the history of the settlement and went on to explain her methodology of investigation and protection. She did not disagree that the GeoFIS had pulled up very interesting results, extending over 20 or more acres. We note that the migration strategy produced by AOC is damage limitation, aptly illustrated by the no-dig principle on the parts of the site which appear might aid our understanding of our heritage greatly. So it is that the 201 trial trenches methodology proposed on the rest of the site has raised considerable concerns due to the extensive investigations, glossing over what happens if significant finds are made that would lead to a more significant dig. Trial trenching is by its very nature a starting point more for investigations and digging in archaeological terms. This methodology will be a part of conditions, and we'd expect our input from local archaeological experts as well before final agreed solutions are established. So back to Mr. Jackson's presentation and moving to the built heritage. He emphasised the importance of the settlement and the area with some 67 listed buildings within 2 kilometres and some 43 within less than 1 kilometre of the solar site. These include 3 Grade 1 properties and 5 Grade 2 star. The Great Wymley properties are all set within the conservation area and washed over by the Greenbelt. The importance of the heritage setting and landscape was emphasised by Mr. Jackson, and the acceptance of this principle that the approach to such assets is in an important dimension. Whilst a number don't have direct views of the proposed solar array, this in no way diminishes the importance of their wider setting. The Priory, which we visited yesterday, is the closest property, and as a scheduled monument, it is our belief that the scale and adjacency of the proposed development would harm its setting as well, potentially its fabric. So in summary, we have very rich heritage we can be proud of, which requires much deeper understanding. Our heritage is visual and contextual, joined up, in the case of Great Wymondley, has for 2,000 years been tied to the land. As a village, and even individuals who own listed properties, we feel the importance of preserving our heritage. For example, raising £300,000 to preserve our 900-year-old church. Ms. Roy contends that the proposals will cause harm, but at a less than substantial level. If we're going to use the scale of harm proposed by Ms. Roy, we feel that even at the less than substantial end, there is enough heritage assets to result in more significant weight. JOG therefore contends that proposals would only damage the setting heritage assets in their landscape, but with the archaeological plan proposed would destroy much of the site. Now move on to agriculture. So I got a frog. We need a frog mitigation strategy now. Jed Griffiths presented on behalf of JOG on agriculture. He made clear the policy position from NPPF 174, where he stated that planning policy and decision-making should contribute to and enhance the natural and local environment. To quote, recognizing the intrinsic character and beauty of the countryside and the wider benefits from the natural capital and ecosystem services, including the economic benefits of the BMV agricultural land. So BMV land is considered to be grade 1, 2 and 3A. We have no grade 1 in Hertfordshire, so grade 2 is our best. The NPPG advises that solar PV development proposals should be focused on the lower grade 3B, 4 and 5. We have established from Mr. Kernan that having undertaken soil samples on the land, the split is 32% grade 2, 68% grade 3. This is split between the north and south parcels. What became clear and is of great concern was that Mr. Kernan did not put great value on the quality of agricultural land and indeed our need to retain it for our food security. Whilst grade 2 lands forms some 19% of Hertfordshire's land use, this is surely not a reason to dismiss its importance. The purpose of the definition of versatility is to have flexibility to change crops in the future to meet need and circumstance. This attitude was clearly prevalent from the outset of the site selection, as little was done to review grade 3 land to establish if any location could be found that would use the lesser grade 3B land. This is subject that another inspectors have referenced in recent cases, particularly in Swadlincote, Derbyshire. Whilst collectively the benefits arising from the appeal scheme are significant, the harm that would be caused by allowing development on just 50% of the site hectareage over a 40-year period would be of greater significance. So if I now move on to ecology and biodiversity, our ecology witness, Mrs. Elizabeth Hamilton, pointed out in her proof of evidence that biodiversity is a material consideration in all public decision-making, pursuant to Section 40 of the Natural Environment and Rural Communities Act 2006, updated via the Environment Act 2021. She suggested that this duty should be taken more seriously, with an awareness of the species on any site which might be displaced or substantially diminished by development. She said that as reported in Jan 23 by the Office of Environmental Protection, between 2013 and 2018, there was a 17% decrease in the abundance of priority species, comprising part of a chronic decline of 82% between 1970 and 2018. Decisions taken on every site count to reverse the decline since 1970 and meet current targets. Also, she pointed out that paragraph 179B of the National Planning Guidelines requires plans to promote the protection and recovery of priority species, otherwise known as Section 41 species. Mrs. Hamilton noted that within the Ecological Assessment Report, the Breeding Bird Survey found that 10 notable bird species were considered to be breeding within the site, of which 9 are Section 41 species. 8 are red-listed species. Yeah, here we go. And conservation concern, and 5 are listed as species priorities within the Hertfordshire Local Biodiversity Action Plan. The EAR stated that of these species, only skylark is the ground nesting species typically associated with arable fields. Mrs. Hamilton referenced CD 223, which stated that yellow wagtail and grey partridge are ground nesting birds of open habitats. These species had territories recorded on the site in the Breeding Bird Survey. Typically, the margins around the solar arrays are used for vehicle access, as shown by the aerial view of the Shuttleworth Hall solar array in Lancashire, included in her evidence. This can be expected to cause disturbance and displacement to birds, which nest in hedges and forage on the ground alongside such edge habitats, including yellowhammer, as recorded as having 9 territories on the site. Mrs. Hamilton disagreed with paragraph 4.7.12 of the EAR, which concludes that the local breeding bird assemblage is unlikely to be adversely impacted by the proposed development. She said that, in her opinion, at least one and potentially several ground nesting breeding species will be negatively impacted. This was particularly the case with skylarks, a Section 41 species with red-listed species recording in the Breeding Bird Survey as having 19 territories, although 4 of these were then subsequently found to be in land outside the red line. The appellant's ecological witness, Mr. Howard Fern, stated during cross-examination that part of the Breeding Bird Survey was conducted on the land outside the proposed site. So Mrs. Hamilton referenced several sources which confirm that no skylark nests have been found within a solar array in the UK to date. She went on to quote extensively from CD 223 with regard to skylark compensation measures, from which it is clear that such measures require detailed knowledge of the proposed compensatory fields, including evidence of existing use of skylarks. In respect of the draft condition 21, the illustrative skylark plot plan dated August 23, Mrs. Hamilton added to her evidence with the following verbal comments. It was not clear whether there had been any survey work on the proposed fields, certainly not on all of them, to ascertain the presence of existing skylark territories or the suitability of the fields. No written evidence had been presented for the management of the skylark mitigation measures proposed for the duration of the proposed solar array. And it was clear from CD 223 that skylark mitigation measures are not guaranteed to be successful. If in the future the proposals were found to be unsuccessful, skylarks, which were expected to be displaced by the proposed solar array, would not have been compensated for. This indicated that the proposed draft condition failed the test of reasonableness. Mrs. Hamilton noted that the EAR reported Hertfordshire Ecological Record Centre records of 7 species of bat within a 2 kilometres of the site. The EAR also noted the presence of potential bat roosts, as well as commuting and foraging habitats within the site and nearby, with good connectivity to higher value habitat, and concluded that the site has moderate value bat foraging and commuting habitat. She also noted that all bats are European protected. Given the likelihood that bats are using the site, Mrs. Hamilton said that a recent research paper is relevant. She noted that no bat surveys had been carried out, and she was not aware of specific bat mitigation measures or lighting strategies for bat protection proposed by the applicant. Mrs. Hamilton said that paragraph 4710 of the EAR suggested that the arable fields would be replaced with species-rich wildflower grassland, but this is not correct. The majority of the area, comprising the land within the security stockproof fencing, would be sown with a grass mixture with 2 varieties of just 1 broadleaf species, white clover, as described in paragraph 3140 and table 2 of the Planning and Design Access Statement. With much of proposed grazed diverse pasture areas under the panel, it's the effects of the shade significantly reduced temperatures and dry conditions may impact on the successful establishment of the proposed sward. I'll now move on to flood risk and drainage there. We accept that we have a flooding issue at the present time in Priory Lane and Stevenage Road, and this was well documented in the Neighbourhood Plan Section 8. And indeed, some late evidence came in on Wednesday evening with a tremendous storm that managed to flood Priory Lane. But the evidence had luckily disappeared by the time you started your walk. The applicant has now produced a scheme with some additions of ponds and attenuation basins that has finally received the approval of the Lead Flood Authority after a number of iterations. Whilst we are told the scheme will bring marginal benefits, there are unknowns, including the impact of the major archaeological dig, the potential loss of land drains, and the general introduction of a built environment of roads, buildings, etc. Such change brings risk and uncertainty to a situation that has no slack to the village downstream. The council and applicant considered no harm and minor benefits. Having heard the evidence and the potential unknowns following the archaeological and agricultural evidence, we conclude on a more neutral position. Moving on to transport, we have heard Mr. Kendall's presentation and note his assertions on levels of vehicle movements and impacts from the proposed works, and particularly the cable laying. Jog was able to speak on transport briefly and question Mr. Kendall. I will not dwell too long on this subject, but just reinforce the key points debated and then picked up in the paper put forward by the applicant. I also note and agree there is significant more to be covered under the conditions. Laying the cabling down Priory Lane and along Stevenage Road will cause enormous problems. The location and height of the Little Winery Railway Bridge necessitates a number of vehicle movements down Priory Lane to Old Hall Farmyard every day. Disruption will be very damaging to local businesses and their financial viability. Working closely with property owners, diversions and steel plates to allow access will all be important elements of the solution. The same will be the case for the Priory wedding trade. Access must be retained for events, or again, trade will and income will be lost. So moving now to noise and vibration. In our evidence, both Mrs. Simpson and Mrs. Hamilton raised the concern about noise. Mrs. Simpson stated that the impact could be felt by those walking the paths, potentially nearby properties, and those enjoying the recreation ground and working in the community orchard, as well as the risk to nearby houses. The potential for deflective noise has also been raised. The example from Todd's Green was quoted, where to shield a new housing estate from the A1M, a large wall, some 9 meters or so in height, has been constructed. The impact has been to bounce the noise back onto Stevenage on the other side of the A1M, magnifying the traffic noise. The matter remains unresolved, with each party blaming the other, whilst the residents suffer. Our concern in terms of the solar array is that by removing much of the natural agricultural carpet and replacing it with 160,000 noise deflectors, there is a risk of noise to the local villages. Mrs. Hamilton gave evidence based on her visit to Folly Farm solar array at Long Marston in Tring, where she was able to hear a very audible sound from the inverters from a public footpath running by the site. She rightly raised the concern that with 22 inverters on this site, some close to the public footpaths, particularly the Hertfordshire Way, we could experience significant noise disturbance. If that is the case, it will have an impact on wildlife, humans, and particularly bird and bat populations. In addition, there will be significant noise during the construction phase from the work to pile in the 32,000 posts. Working hour limitations have been included in conditions, but noise will be inevitable. The council, in their assessment of harm, weighed noise as neutral with no weight. It is hard to be able to rationalise this assessment given the evidence that we have heard and the basic inevitability of building a vast industrial scale development. We consider there to be harm, and that harm will be initially substantial, reducing, one would hope, to moderate. I now turn to fire risk. As you are aware, sir, we have from the outset raised concerns about fire risks coming from battery storage units, particularly. I referenced in my opening statement the result and follow-up of investigations following the Liverpool fire. We have also tabled communication from Herts County Council in respect of fire risks. With the Herts Way meters from the battery storage units, as well as Great Wymley Wreck close by and a number of houses, this risk must be taken seriously. The fire service say they require dual access points to each part of the site, a perimeter road, dry system installation, emergency water and hard standings. We are not saying that we would wish to see such a solution, but what we do need to be satisfied is that the risk is taken seriously. This is another matter which has been added to the conditions, and one we feel strongly would wish to review when the consultation exercise is complete. What is clear, that we now know to be 100 megawatt BESS storage on site, these risks are very real. We've seen confirmation in the last couple of days that the government shares that view and is planning on introducing the need for such facilities to require an industrial installations permit. So if I may come now on to community harm, Mrs. Simpson appeared on behalf of our community. She explained that both professionally and as a mother, she's passionate about the countryside, our setting within it, and all our rights to be able to have peaceful enjoyment of the rural setting of the parish we have chosen to live in. She was able to speak on behalf of the 90% of the village population who registered their objection to the application. She spoke of her work with a fitness app, which is working to improve the nation's health by encouraging more regular exercise. She particularly referenced the importance of the Hertfordshire Way that everyone in the village accesses via the path at the top of the wreck. The importance was emphasised by Mrs. Simpson for health, family time, walking, running, cycling and dog walking. It also gives safe access to the greenway around Letchworth, so it is a real route out of the village that goes north, east and west. The roads from the village do not have paths, so emphasising even more the importance of our footpaths and the Herts Way in particular. And then there is also a mental health benefit, as explained by Mrs. Simpson. The views in the changing seasons and agricultural activity that are an intrinsic part of the experience of going into the countryside will be lost, replaced by the monotony of a single unchanging vista of solar panels. This will be explained, will have a negative effect on people's mental health and well-being. And the fencing and CCTV were also referenced and are of grave concern. One parishioner came into my house yesterday as I sat writing this speech. This lady had been running out on the Herts Way and came straight to me, rather emotional, to make a plea. She had realised when running along the open country that the proposals put forward would involve enclosing the pathways with hedging and trees aimed at securing the solar array. This, she rightly points out, will also have the effect of creating a very frightening proposition for women running alone, which many do, because of the feeling of enclosure, which would adversely impact their safety and confidence to use the tracks. This is a hugely important point that must be taken account of, but of course is at odds with the hide the panels policy and so difficult to reconcile. The proposition, of course, is made even worse when you consider the context of not only hedges, but fencing as well. This leads me on to another point made by Mrs. Simpson in terms of security concerns. We referred to communication from Herts Police in respect of another solar array, where they say theft is becoming a major issue. Whilst we have agreed to protect our rights with regard to fencing, what this worrying trend does is to add to concern about children or lone people being on the footpaths, with possible criminal types being drawn to the area. So I now come to my summary and conclusions. As the joint objectors group of the Great Walmley Village Association and Parish Council, we strongly believe that the application should not be approved due to the harm that it will bring. In this application, we have the perfect storm. Harm to Grade 2 and Grade 3 productive agricultural land, harm to Greenbelt and its purposes, harm to openness and visibility, harm to the setting of 67 listed buildings, harm to the conservation area, harm to archaeology spanning thousands of years, harm to wildlife and their natural environment, harm to public rights of way, harm to the community's safety and well-being, all weighed against the benefit of clean energy production and storage. We have seen and referenced above other cases where inspectors have not allowed development for just one of the above harms, and generally on sites smaller than the colossal 88 hectares proposed here. So here we have the complete set. The argument put forward for the location is the need to produce the power locally. This, in our view, is not logical or the best use of our natural resources. The power will go into the national grid. As the name suggests, it's national. In the past, no one has insisted we drill for gas or oil here, or try to mine coal, or site a nuclear power station. So why the change of logic? What we have is high quality agricultural land, being put to the best possible use to grow wheat and barley at a time when the world needs us to deliver and be versatile for changing future needs. Furthermore, due to socio-economic reasons, we're also under great pressure to provide more houses and to have had to accept the shrinking of our green belt in the parish to potentially facilitate over 300 homes, doubling the size of Little Wymanley. In addition, we as a parish are already home to a major substation, main north-south train and road links. That surely should not mean by default we have to be swallowed up by solar arrays, so we end up as walled-in Wymanley. Each part of the country must do what it does best for the national good. For us, it is housing people close to their work and transport infrastructure, and to grow arable crops. We rest our case that this application should be turned down. And thank you again, sir, for your time, your diligence, and your impartial attention to detail. Thank you.
Thank you, Mr. Harding. Just a few points I'd like to mention before we move on. Firstly, on page 1, paragraph 1, when you're kind of expressing thanks to various parties, in terms of the administration of the database, I think it's only right to mention that quite a lot of that work's been done by the LPA as well.
Okay. Yeah. Yeah. Well,
just
thank you to them. Well,
moving on, page 11, paragraph 69. You're referring to the quality of the agricultural land, and you talk about 32% grade 2 and 68% grade 3. I think it's actually 3A that the reference should be, not just 3.
Oh, indeed, yes, sir. Yeah, 3A it is, yes. Yeah.
Page 13. This is just something for me to check, having a quick look at the maps while you were mentioning the cable route on paragraph 89. And you talk about Priory Lane and Stevenage Road. And I just want to be clear about the extent of Stevenage Road, because the map I've got showing the cable run names Priory Lane, obviously going past the Priory, down to the railway line, and then to the road at the bottom. Are you talking then about the road at the bottom of Stevenage Road?
The road at the road at the bottom. So the road that runs
where you turn right.
Yes,
Priory Lane.
Yes,
that's Stevenage.
Yeah. I mean, it is sometimes called High Street, but it's actually strictly Stevenage Road. Yeah.
Right. And then finally on page 15, paragraph 100. The reference in your second sentence, you say, we've seen confirmation in the past couple of days that the government shares that view about risks that you've referred to earlier in paragraph 899, and you refer to plans to introduce an industrial installations permit. I'm not sure that's been mentioned previously in the inquiry.
It hasn't. So no, that was just literally something that crossed over me, that that was pertinent to
okay, but I don't think I've got anything else about it.
No, I mean, I'll be absolutely honest with you, I don't quite know how I came across this bit of information, but it's a letter from the planning minister.
Okay. I just want to make it clear, I haven't got that before me.
No, would you like it? I think I have.
No, I'm not.
I have
at this. Not at the stage.
No,
not at this
stage. No, fine.
Okay. Thank you, Mr. Harding. Those were just the points that I wanted to clarify. I'm going to adjourn for a short break in a moment. But before I do, I would like to take up the offer from Mr. Hardy to put forward Mr. Collier as chauffeur again, and just to do that A1M circuit. It is, of course, on the important proviso, as with yesterday, that I am accompanied by somebody from JOG and Mr. Robinson, assuming that they're both available. As Mr. Hardy indicated, I don't think it should take too long to do.
For lunch, one would hope. Subject to which, yes, I will be available.
Thanks, Mr. Robinson. Yes, it would be my intention to conclude everything here and then to deal with it. So,
yes, that's fine, sir. I'm
Good.
certainly available.
Good,
Yeah.
thank you. Right, we'll adjourn now, please, and the inquiry will resume at 11:30. Thank you. Just time to resume.
Yes.
Just a quick word. Before I embarked on closing submissions, I should have checked, as I said I would do, whether there was anybody else present who wanted to be heard at the inquiry. I think, as far as I'm aware, everybody here is associated with one of the three main parties, but I just do need to quickly make that check before I go any further. No, nobody's indicated. So, Ms. Daly, can you proceed, please?
Just raise one point, and that
sorry.
is, we've been combing through the core documents. We've noticed that there wasn't a specific request to include Mr. Harding's response to the technical note in relation
Mentioned
to
it this morning.
Just to confirm,
to put it on the core document list.
Oh yes, there's an inquiry document. Yes,
Right.
I said that was one of the documents I'd received. Yes,
Fine. So we'll,
sorry if I wasn't sufficiently explicit, but yes,
Fine.
That must be on.
yes, sir. I've taken it that anything you announce at the beginning of a day as
Yes.
documents you've received are documents to go into
Absolutely.
the core documents
Unless
list.
I say not, such as the
Fine.
appearances list.
fine. Thank you.
Good. Okay, I've already distributed
Yes,
copies of
I've
my
got it.
closing to the parties and to you, sir. So I will begin.
Please.
The central issue for resolution in this application is whether the significant national and local benefits that the proposal would deliver in its contribution to a growth in solar deployment, along with its other benefits, clearly outweigh the harm to the Greenbelt and other harm. The Council has carefully considered the balance of benefits and disbenefits that the proposal would bring, and judges that in this instance, the harm to the Greenbelt by reason of inappropriateness and other harm is clearly outweighed by the benefits. It invites the Secretary of State to come to the same view. These closing submissions provide a summary of the Council's case, and they're structured having regard to your, sir, identification of the main issues on the opening day of the inquiry. And I won't read them, but I've provided the list there. So the first main issue is the effect of the application proposal on the Greenbelt. The proposal will cause harm both to the openness and the purposes of the Greenbelt, to which the Council attributes substantial negative weight. In terms of openness, the Council has judged that the proposal will give rise to significant harm to the openness of the Greenbelt, both in spatial and visual terms. In respect of the spatial element, Mr. Robinson was in no doubt that the introduction of development into an area of land where currently there is none would diminish the openness of the Greenbelt. However, he recognised that having regard to the approach taken by Mr. Mason and the comparison that he drew with a Greenbelt housing development, the extent of the spatial effect would be moderated to some extent by the open areas between and under the solar panels and the various landscape buffer zones incorporated into the design of the scheme. In relation to the visual impact on openness, this adverse impact would relate principally to an intermittent range of views around the site, but in accordance with the analysis undertaken by the applicants, LVIA, and the Council's consultants, TLP, this impact would in time be mitigated by the proposed planting. The applicant's evidence through Mr. Kendall dealt specifically with transport-related Greenbelt harm. As Mr. Robinson explained, he did not address transport-related harm as a separate topic in his analysis, in part because he did not consider that it would be at all substantial and would rather result only in a low impact on the Greenbelt for a temporary period. The Council stated in opening that it attributes limited weight to the temporary nature of the proposal in the context of Greenbelt harm. That continues to be the case. When asked by JOG about this, Mr. Robinson acknowledged the concern behind their objection to the description of the development period as temporary, namely the fact that it would be in place for a considerable period of time. The Council recognises the lengthy period of the consent, and this is why it gives little weight to the temporary nature of the proposal. However, it is clear that in planning terms, as Mr. Griffiths agreed, the application is for a time-limited and reversible consent and must be considered on that basis. With regard to Greenbelt purposes, the impact of the proposal in relation to the purposes of the Greenbelt is judged by the Council to constitute limited harm to purposes A, check the unrestricted sprawl of large built-up areas, and B, to prevent neighbouring towns merging into one another, as well as significant harm to purpose C, to assist in safeguarding the countryside from encroachment. With regard to the view expressed by Mr. Griffiths that purpose A is principally related to checking sprawl from London, Mr. Robinson had no reason to question Mr. Griffiths' view on the original intention of the policy, But in his view, the straightforward wording of the purpose encompassed built-up areas in larger towns such as Stevenage, Letchworth and Hitchin, with the effect that the application proposal engaged this purpose. With regard to purpose D, Mr. Griffiths' view was that it was not engaged, as it is limited to major historic towns in England such as York, Bath, Oxford and Cambridge. Mr. Robinson took a more expansive view as to the ambit of purpose D, but considered that in this case, there would be no appreciable impact on the historic towns of Hitchin, Letchworth, and to a lesser extent Stevenage, given the distance of the application site from those towns. Given that the Council considers that the very special circumstances test is made out, it does not consider that the proposal conflicts with NPPF Greenbelt policy or local plan policy SP5. It does, however, consider that there would be some conflict with Wymondley Neighbourhood Plan Policy GB1, which defers to national policy, but further states that development proposals should not impact negatively on Wymondley Parish, particularly in terms of visual impact on the openness of the Greenbelt landscape. Finally, taking a step back from the specific impact of the proposal on the Greenbelt and considering the status of the North Harts Greenbelt more generally, one of the themes pursued by Mr. Griffiths in his evidence related to perceived pressure placed upon the North Harts Greenbelt in recent years through the release of Greenbelt land for housing through the now adopted NHDC local plan. This presented an incomplete picture of the position. When taken as a whole, as Mr. Robinson explained, there has in fact been a net gain in Greenbelt in the North Harts area following the adoption of the local plan in the region of approximately 4,000 hectares, resulting in the Greenbelt coverage of the district rising from approximately 38% to approximately 47%. This is due to the substantial new area of Greenbelt around Offaly and Whitwell added through policy SP5B of the local plan. Any consideration made of recent loss to the Greenbelt when considering the merits of this application should also have regard to the overall gain in recent years. The implications of the proposal for meeting the challenge of climate change. All parties to the inquiry, including JOG, accept that at very least significant weight should be attributed by the Secretary of State to the proposal's contribution towards the production of renewable energy, as supported by Chapter 14 of the NPPF. The draft NPS EN3 is accepted by all parties to be a material consideration in the determination of this application and an articulation of the most up-to-date government thinking on issues relating to solar development. It confirms the government's commitment to sustained growth in solar capacity to ensure that we are on a pathway to meeting net zero emissions. It describes solar as being a key part of the government's strategy for low-cost decarbonisation of the energy sector, aligning with the Energy White Paper's description of solar as one of the key building blocks of the future generation mix. The draft NPS also recognises the important role that solar has to play in delivering the government's goals for greater energy independence, and it expresses support for solar development that is, as here, co-located with other functions such as agriculture to maximise the efficiency of land use. The NPS references the British Energy Security Strategy statement that the government expects a 5-fold increase in solar deployment by 2035, with the current approximate capacity being 14 gigawatts. As Mr. Griffiths recognised, solar is central to the government's decarbonisation plan. Having regard to the applicant's assessment that it would produce the equivalent of the electricity demand from approximately 31% of the homes within the council's administrative area, the council considers that this development would make a very significant contribution to providing energy from a renewable source. In relation to the council's declaration of a climate emergency in 2019 and the ambitious target that it has set itself of achieving a net zero carbon district by 2040, Mr. Griffiths accepted that if this is to constitute something more than nice words, something has to change or things need to be done differently. In resolving to grant consent for this scheme, the council has sought to take such a positive step towards achieving its target in a context in which it has consented no solar farm development since 2015 and has only a very modest current provision of solar farms. The Council's view is that the proposal is strongly supported by national and local policy regarding the deployment of renewable energy, and that very substantial positive weight should be accorded to its contribution towards renewable energy generation at a national level and meeting local needs respectively. In terms of the approach to local policy, Mr. Robinson explained the Council's view that where a proposal is for a solar farm involving the best and most versatile agricultural land, policy NE12 defers to national policy, and that the criteria in NE12 do not apply to such proposals, albeit the criteria that would otherwise be relevant have in any event been addressed by this application. In relation to national policy, as Mr. Robinson explained, the revisions made to the NPPF in the immediate run-up to the inquiry, specifically in relation to paragraph 155A, are not relevant to the determination of the application, given that they relate to plan making rather than decision taking, which is covered by paragraph 158. Finally, in relation to the policy approach to renewable energy in North Hertfordshire, a theme of JOG's case was that renewable energy developments of the scale proposed by this application should be considered through a strategic approach in a development plan. The absence of the site's allocation in a development plan for solar or other renewable energy development is not an impediment to permission being granted. The local plan does not allocate any sites for renewable energy, although local planning authorities are encouraged by paragraph 155B to identify suitable areas for renewable and low carbon energy sources where this would help secure their development. There is no national policy imperative to do so. Further, and in any event, as Mr. Robinson explained, it's perfectly usual for local planning authorities to consider and approve proposals for development that have not been specifically allocated in a development plan. The world does not stand still whilst new development plans are being prepared and working their way through the system. There is an imperative at national level for the speedy delivery of renewable energy and no requirement that it only be delivered on allocated land. Turning then to the effect of the proposal on the character and appearance of the area. The landscape and visual impacts of the proposal have been one of the central concerns of the local community during the inquiry, as articulated by JOG. As ever, landscape and visual impacts are best discerned through a site visit, and the inspector will now have had the opportunity to consider those impacts on the ground to inform the recommendation to the Secretary of State. In visual terms, part of the concern on the part of the local community appears to have arisen from a misunderstanding of the landscape mitigation proposed and its likely screening effects in the medium to long term. A useful comparison can be drawn between the images produced by Mrs. Simpson in her presentation with red blocks designed to depict the perceived effects of the proposal on the enjoyment of local footpaths and the professionally produced viewpoints in the applicant's LVIA. The Council considers that it is only the latter that present an accurate assessment of the visual effects. The Council takes the view that there will be both landscape and visual harm caused by the proposal, but not of the nature or extent that the community fears. The impacts will be localised and will not extend to the Chilterns AONB, as agreed by the professional landscape consultants, Mr. Mason and TLP. The conclusions of the Council, informed by TLP, are broadly similar to the conclusions reached by the applicant's LVIA. The Council takes the view that there would be significant landscape harm in that the proposal would result in moderate to major adverse impacts at the site and local scale in landscape character terms, but that improvements to the landscape character area would be achieved following decommissioning due to landscape mitigation measures. There will be some significant adverse effects in respect of views from parts of the Hertfordshire Way in the early years of the operation of the development, but these would be effectively mitigated through planting, such that the medium to long-term effects would not be significant. The Council's position is that the adverse landscape character and visual impacts of the proposal should be given moderate negative weight in the planning balance. It considers that although the proposal is not in landscape terms unacceptable overall, the harm gives rise to an element of conflict with policy NE2 of the local plan, specifically criterion B. Habitats and biodiversity. There has been no objection to the proposal from any nature conservation organisation or consultee. Most recently, Hertfordshire Leeds wrote to the Council on the 15th of September to confirm that following the submission by the applicant of a revised BNG assessment based on the updated metric 4, its advice remained that the application could be determined with no ecological objections subject to conditions. The Council accepts its advice that the predicted biodiversity net gain is ambitious but in principle can be achieved, and that BNG well in excess of the government's proposed minimum requirement of 10% would be delivered, and that impacts on biodiversity do not represent a fundamental constraint on the proposed development. When asked by the inspector to provide her overarching view on the ecological impacts of the proposal, Mrs. Hamilton expressed an in-principle objection to any solar development on greenfield sites. This is wholly inconsistent with the national and local policy approach towards the location of solar farms. It's also inconsistent with the acceptance by Mr. Griffiths that the applicant has demonstrated that given local constraints, there is an in-principle need for this development to be on a greenfield site. Leaving that matter to one side, her focus in terms of ecological matters reflected a concern about appropriate management of solar farms in order to achieve biodiversity net gain, and a concern particularly with regard to bats and ground nesting birds about the success of mitigation strategies. Mrs. Hamilton's input to the inquiry has resulted in proposals by the applicant for a more robust set of ecological conditions to secure, for example, a skylark mitigation strategy, with which the council is content. Based on the advice of Hertfordshire Leeds and the applicant's evidence, it does not, however, consider that her objection is an impediment to the approval of the proposal. The matters about which Mrs. Hamilton was concerned are appropriately addressed by conditions, which require further details to be submitted and agreed by the council in due course. Heritage assets. The council, the applicant, and Historic England's views as to the heritage impact of the proposal are in broad alignment. It is agreed between these parties that the proposal would give rise to less than substantial harm at the lower end of the scale to a number of local designated heritage assets through development within their setting. By contrast, the position of Mr. Jackson in identifying that there would be substantial harm to a large number of local designated heritage assets is that of an outlier. Mr. Jackson was plainly passionate about the history of the Wymondleys and their buildings, particularly those in Great Wymondley. However, he has no professional qualifications in relation to heritage matters and has never authored a heritage impact assessment. He also appeared to be unfamiliar with the NPPF approach to the categorisation of harm to designated heritage assets, and when asked about this, his on-the-spot assessment that the proposal would result in substantial harm was not reasoned or indeed credible, having regard to the gulf between his view and that of suitably qualified experts. His criticism of Historic England and the applicant for being insufficiently thorough in their analysis of the impact of the proposal betrayed a lack of understanding of the proportionate approach to heritage analysis advocated by paragraph 194 of the NPPF. He was not in a position to make the same criticism of the council because he had not seen fit to read the officer's report to committee, which sets out the council's views on the heritage harm, before drafting his written evidence or appearing at the inquiry. In this context, the weight that should be afforded to his evidence is very limited. By contrast, the Inspector and Secretary of State have before them a broad harmony of views from the government's statutory heritage body, as well as the applicant's heritage witness and the council. The views of suitably qualified heritage professionals should be given substantial weight, and in particular, the advice provided by Historic England should be given considerable weight and only departed from for cogent and compelling reasons. Mr. Jackson presented no such cogent or compelling reasons to do so. With regard to the impact of the scheme on archaeology, Mr. Jackson was extremely keen to emphasise the potential archaeological significance of the site, but that is not in dispute. The council and the applicant recognise that the site, in the light of the conclusions of the applicant's geophysical survey and the advice received by the Hertfordshire County Council Archaeological Advisor, has high potential for significant archaeological remains. The council, on the advice of the HCC advisor, is satisfied that the mitigation strategy put forward by the applicant to be secured by condition, which includes substantial no-dig areas in the locations of high potential and post-determination trial trenching across 3% of the remainder of the site, is appropriate and accords with relevant national and local policy. As Ms. Roy explained, 3% trial trenching is an industry standard. Mr. Jackson's objection to no-dig areas on the basis that the preservation of remains of potentially significant interest in situ would not further understanding of the Wymondleys' history reflected a personal wish to discover more about the area. It did not reflect the approach of policy HE4 of the local plan or the clear policy preference expressed in the draft written scheme of investigation. As Ms. Roy explained, preservation in situ is considered to be very important and preferable in this instance because it allows the preservation of the remains for future generations when there may be a better understanding of archaeology and advances in archaeological methods. As for the potential impacts of the use of ground-mounted solar panels in no-dig areas and trial trenches on best and most versatile agricultural land, Mr. Kernan did not consider that these would affect land quality. Similarly, Dr. Tilford did not consider that either measure would result in adverse impacts in respect of drainage from the site. Whether the proposal is consistent with policies and guidance regarding the use of agricultural land. The most recent government thinking on best and most versatile agricultural land is that expressed in draft NPS EN3, which states that land type should not be a predominating factor in solar site selection. It also states that where possible, PDL, brownfield, contaminated and industrial land should be used, and that poorer quality land should be preferred over higher quality land, avoiding the use of BMV where possible. As Mr. Griffiths pointed out, this is a watering down of the statement regarding BMV in the previous draft NPS EN3. He also expressed the view that policy on agricultural land in general has been watered down over a 50-year period, such that national policy is now only to consider its benefits in decision-making, as per para 174B of the NPPF. Mr. Griffiths accepted that the government's watering down of this policy in respect of solar farms reflects the fact that pressure from competing interests is now different to some 50 years ago, and that there is a government acceptance that solar farms will need to be on agricultural land and greenbelt where appropriate. Although the written ministerial statement from 2015 refers to compelling evidence being required for solar farms to be located on BMV land, this is now rather aged, and as Mr. Robinson pointed out, countless documents have been produced by the government since then, including several revisions of the NPPF and the draft NPS EN3, which do not prohibit solar development on good quality agricultural land. In terms of the use of grade 2A and 3A agricultural land in this instance, Mr. Kernan explained that grade 2 and 3A land is not rare in the local area, and that for practical purposes, there was not much difference between the two categories of BMV found on this site. He also explained the practical difficulties in undertaking a desk-based exercise to identify poorer quality agricultural land, given the limitations of the Natural England maps, which date to the 1970s, and the fact that it is only when one goes to site with a soil auger that the actual quality can be determined. Importantly, this proposal will not result in loss of best and most versatile land, given that the proposed conditions secure sheep grazing during the operation of the development. The Council does consider that negative weight should be attributed to the loss of productivity or flexibility in terms of agricultural production, but does not consider that the proposal is inconsistent with policy or guidance on BMV use. In terms of weight, Mr. Robinson now takes the view that this should only attract limited negative weight in the light of Mr. Kernan's evidence regarding the scale of contribution to cereal production presently made by the site in a national context. Dealing then with other matters on flooding, it's accepted by all parties to the inquiry that the flood risk and drainage strategy proposed by the applicant will result in a betterment in terms of flood risk in Little Wymondley. As Dr. Tilford explained, research suggests that solar farms have a negligible effect on the hydrological response if the site comprises of grassland, and that given that the application site currently comprises bare earth for part of the year, that change in itself will be likely to reduce runoff rates. However, the scheme includes 6 attenuation storage areas as a belt and braces approach to ensure that the development will result in a significant betterment in terms of the runoff from the site and a marginal betterment within Little Wymondley, having regard to the fact that the site is only a small contributing part to the catchment that causes flooding in the village. As confirmed by the Council in the Conditions Roundtable, the applicant, the Council and the lead local flood authority have now agreed a set of conditions that will secure the betterment described by Mr. Tilford. The Council is satisfied that the proposal meets relevant development plan and national policy in Chapter 14 of the NPPF in respect of flood risk, and takes the view that the modest betterment to the flood risk position in Little Wymondley is a benefit to which limited positive weight should be attributed in the planning balance. The Council is also satisfied with the additional wording suggested by the applicant in its technical note produced during the inquiry in relation to proposed conditions in order to manage the cable laying works, specifically in respect of the storage of spoil and the management of flood risk during the excavation of cable trenches. On site selection, the officers' report to committee noted that national policy and guidance does not set a sequential test whereby non-greenbelt land must be considered before greenbelt land for solar farms. The report further noted that physical restraints were likely to influence the site selection process, such as access to the national grid or capacity limitations. This reflects the subsequently published draft MPS EN3, which describes the capacity of the local grid network to accept the likely output as critical to the technical and commercial feasibility of a development proposal, as well as advising that land type should not be a predominating factor in determining the suitability of the site location. It also reflects the applicant's site selection process as explained by Mr. Collier, which due to network capacity and curtailment issues, as well as substation constraints, both in terms of the substation itself and the practical challenges of cable running to it, landed upon the Wymondley substation as the deliverable and achievable option within the area. Turning then to the planning balance, the benefits and harms. The harm side of the equation comprises harm to the greenbelt, landscape and visual impact, heritage harm, and harm through the loss of flexibility or productivity of BMV. In relation to benefits, beyond the very substantial and substantial positive weight attributed to the contribution made to renewable energy generation in general and in North Hart specifically, the Council also considers that positive weight should be attributed to the economic and energy security benefits, significant weight, the biodiversity net gain, moderate weight, the achievement of betterment to local drainage and flood risk, limited, and the introduction of new permissive footpaths for the duration of the operation of the development, minor. The heritage balance, paragraph 202 of the NPPF identifies that less than substantial harm to identified heritage assets must be weighed against the public benefits of development proposals. The Council's position is that the public benefits are cumulatively of sufficient weight to outweigh the low level of less than substantial harm to designated heritage assets. Very special circumstances. The impact of the proposal on the Greenbelt would be substantial and harmful, even though it would not be permanent. In this case, the Council considers that the Greenbelt harm, taken together with the other harms identified relating to landscape and visual impact, heritage and loss of agricultural land productivity, is clearly outweighed by the public benefits, taken as a whole, but with particular regard to the climate change context and the need to accelerate deployment of renewable generation at a national and local scale. The effect of this is that it is the Council's view that the very special circumstances test is met on this occasion. Finally, whether the application proposal is overall in accordance with the development plan. The proposal gives rise to some conflict with policy NE2 of the local plan and Wymondley Neighbourhood Plan Policy GB1 in respect of landscape and greenbelt matters, but it otherwise accords with relevant policies of the development plan. Taking the plan as a whole and considering the limited policy conflict, the Council's view is that the development is in accordance with the development plan and that material considerations do not indicate that permission should not be granted. And on that basis, it's the Council's view that the application should be granted consent, and it invites the Secretary of State to permit the development proposed.
Thank you, Ms. Daly. Mr. Hardy, please. Thank you very much. Ms. Daly, could you also send a Word document to Alison Dyson? Mr. Hardy, likewise, can you arrange for the same? Yeah. When you're ready, please, Mr. Hardy.
Thank you very much. Obviously, I've got the last word and normally would go back on points of corrections or things that I wanted to comment on. There's really not many, apart from one correction from the JOG submissions, and it relates to paragraph 33, where what's said is from evidence provided by Mr. Hoyle, it seems that a robust brownfield investigation was not undertaken. Indeed, the Council's brownfield register was not even reviewed, nor was rooftop solar given any serious consideration, even though it is becoming an ever increasingly important element of the solar industry. The planning statement, so that's CD2. and it's paragraph 5.3.59. So 5.3.59, it's internal page 64, and this is in the section in relation to the what was done. I'll just read it out. Firstly, brownfield sites were considered by reviewing the North Hertfordshire Brownfield Land Register 2020. No sites which are over 5 hectares and no site within 4 kilometres of the grid connection point. Largest brownfield site is only 4.01 hectares, not of sufficient size to explore developing a subsidy-free for solar energy development. So if the paragraph is suggesting that there wasn't a robust assessment done, of course, that's fine. I just wanted to make the point that actually the brownfield register was looked at, and that's recorded in the planning statement.
I wonder if the point arose because of the answer given by Mr. Hoyle.
It may well have done.
Because I think he said, I'd have to check my notes, but I think he said that he hadn't referred to the register.
Mr. Hoyle wasn't involved.
I know.
Yes.
So that I think that's perhaps where the confusion has
It may be. It's in the planning statement, so that's. I just thought that was worth pointing out. The last 8 days of inquiry have provided the opportunity for a rigorous appraisal of the proposed development. Indeed, it's hard to think of how it could have been any more exhaustive, and that's to everybody's credit. There's been a tremendous amount of detail discussed, but the overall position remains exactly as it was at the start of the inquiry. And of course, the agreed position between the applicant and the council is that planning permission should be granted. Council planning officer who understands the development plan policies, the local area, and all that's good about this corner of North Hertfordshire, concluded that whilst there may be tension with some policies in the adopted development plan and framework, there are also compelling reasons to justify the grant of planning permission in the Greenbelt. Equally, planning committee members accepted their professional officer's recommendation and resolved to grant planning permission. As has been made clear throughout, the applicant supports the conclusions in the planning officer's carefully articulated report and recommendation of a subsequent decision by elected members to approve the proposed development. So far as the applicant's concerned, this inquiry is about the acceptability of this solar array in the Greenbelt. A number of important strands were brought together in the evidence of Mr. Collier regarding the site selection process and why the scheme is where it is. It all be too easy to look at a plan such as figure 5.2 and suggest that this solar farm should be out with the Greenbelt and hook into the Reed primary substation. But however, as has been demonstrated, Wymondley GSP is the only substation into which the scheme can connect. None of the identified primary substations can provide the capacity for a suitable connection to the grid for the proposed development. And the overriding point is this: it's not an academic exercise. This is about getting much needed renewable energy generation built. So as identified in the planning statement, it could be possible to connect into the transmission 132 kV stations, identified in the planning statement, paragraph 5.4.73. 2 of those within North Hertfordshire, another 4 within 4 kilometres of the district boundary. An application was made to National Grid for a tertiary connection at Wymondley. That's a specific type of connection for a project of this size and is not available at all transmission level substations. The reason for connecting at Wymondley rather than other substations was for the type and viability of the 33/13 kV connection. All other transmission level substations would have experienced high curtailment, and even if there was capacity, would have resulted in a disproportionate connection cost due to the connection voltage and location. As Mr. Collier explained, a key point of difference for transmission connections is that they could be secured at that time without having identified a specific site. That meant the developers could secure the grid connection and then run a detailed site assessment across a number of sites, approach landowners and identify a site that was deliverable and available within an appropriate distance. Mr. Collier also explained a distance of 4 kilometres is considered to be the maximum distance radially from the point of connection to a site. That's an industry standard area of search. Beyond that, the evidence was of an exponential increase in costs and complexity, and the scheme wouldn't be built. Can I just break off there? In the JOG submission, there's reference to the 4 kilometres and what other inspectors have had to say. And of course, they're entitled to to take that view. But the evidence here is that is industry standard. And also, if you take the view, well, there's no magic to 4 kilometres, but you went out to 4.5 kilometres or 5 kilometres, would that make any difference? And the answer is no, based on what Mr. Collier had to say. So the evidence from a developer of these schemes is 4 kilometres is where you look. But even if that is not accepted, we say it would make no difference based on the evidence that you do have before you. Whilst they're in the process of securing the grid connection, the applicant engaged a land agent to work on land acquisition. Search criteria set at that 4 kilometres with the need for a land holding large enough to accommodate a 49.9 megawatt solar farm, which is reasonably distanced from residential properties and which took due consideration of the usual planning constraints. Mr. Collier went on to say there are a number of landowners that were interested in engaging with the project. Some were further west, that would put them closer to the AONB. Another site to the south was already in talks with another operator, which has now secured consent for a BESS scheme. So as a result, the application site was chosen because it was available, deliverable, and unconstrained at a high level of appraisal, and it was viable. So you're taking all those points together, there is a compelling narrative for selection of the application site. I think it's worth just noting the conclusions of Inspector Partington on this topic at the Scruton appeal. And we've already had those read out. Perhaps can stay those, keep those, just take them as read. But basically, we're concentrating on capacity and sites around where we know that to be. So paragraph 1.10 of my text, having demonstrated that there are no non-greenbelt alternatives, this case becomes principally one about the impact of a visually contained solar farm on the visual component of openness. JOG raised a host of technical issues, but we say all of those can be dealt with by way of planning condition, or they don't raise an impediment to the grant of planning permission at all. And in that respect, I adopt the conclusions of Miss Daly on behalf of the council, and we're at one at that. And I think just as a general characterization, it's the difference between passionate and articulate local residents and professional views. So it's been very interesting, and the views of JOG, and I have to say Mr. Harding's done an excellent job of presenting that case. But ultimately, they remain the views of passionate, interested local residents. They're not the first to say, we approve of renewable energy, but just not here. And I think that overall characterization needs to be borne in mind when looking at the credibility of the evidence. So the applicant set the inquiry because there's an immediate and pressing need for deployment of renewable energy generating infrastructure across the United Kingdom, which is intrinsically linked to the legally binding obligations to reach net zero by 2050. Every council should seek to maximise renewable energy generation in its administrative area. The proposed development would make a material and appreciable contribution to meeting the amended Climate Change 2008 targets. Central government has emphasised through national planning policy that continued deployment of solar farms and renewable energy technologies more generally are a key part of the UK's transition to achieving a low carbon economy, switching to carbon-free energy generation by 2035 and tackling climate change. In May 2019, the central government formally declared a climate emergency, swiftly followed that with publication of the Energy White Paper, December 20, and publication of the Net Zero Strategy, October 21. Both emphasised the measures required to transition to low carbon energy generation by 2035. Large-scale solar was described as a key building block in the transition. I think it's just worth breaking there too to say, of course, the Prime Minister this week has been in the press for what appears to be a softening or a rollback on some of the net zero targets. That's got nothing to do, in my respectful view, with renewable energy generation. That wasn't mentioned, and the aspiration remains the same. And indeed, part of the problem is about electrification and the absence of infrastructure. So in terms of EV cars, if anything, the need for electrification is getting greater. Part of the reason is that we can all buy electric cars, but you can't power them. So I wouldn't want it to be said, and I'm sure the Secretary of State will be well aware of this, making the decision that isn't a softening of anything to do with the ambition for generation of electricity from clean sources. So that desire to achieve these goals, in part through the deployment of large-scale ground-mounted solar, is evident in recent decisions issued by inspectors and the Secretary of State, including commercial-scale deployment in the Greenbelt. Refer to the Cannon Barnes Road, and also it doesn't take things on materially, but it's interesting from a senior inspector, Inspector Jackson, at the Crays Hall Farm decision, which you've also got in the core documents now. So in this case, based on the detailed evidence that it's called, the applicant submits that the harm caused to the Greenbelt by reason of inappropriateness and any other harm is limited. Benefits flowing from the scheme, including the renewable energy generation, the legacy landscape enhancement, the ecological enhancements, the local economic benefits, are sufficiently great to clearly outweigh the harm. And as a result, the applicant argues that very special circumstances exist which would justify setting aside the usual presumption against allowing inappropriate development in the Greenbelt. 2, I don't need to read out. Those are the matters on which the Secretary of State wanted to be informed. 3, the decision-making framework sets out the development plan. Don't need to read that out. The relevant policies are set out. They can just be taken as read. Other material considerations over the page. We know what the NPPF says and the relevant sections there. So I'm going to turn straight on to section 4, issues on which the Secretary of State wishes to be informed, of the first of those being Greenbelt. In policy terms, all solar farms are inappropriate development in the Greenbelt. I know you know this, sir, but there's been a little bit, I think, of weight placed by JOG on the fact that, that inappropriate sounds as though, well, these things are unacceptable in the Greenbelt. Of course, that's not the case. Just in policy terms, it isn't one of the forms of development that are considered to be appropriate by definition. So it's nothing more than that. And I wouldn't want members of the public to think that somehow policy is saying that these are unacceptable or unwanted in the Greenbelt. There's a policy test, of course, but it doesn't go further than that. So in terms of openness, limited harm to the spatial and visual aspects of the Greenbelt, resulting from a slight reduction in actual and perceived openness, no harm to openness of the Greenbelt resulting from a permanent change in land use, no harm to openness resulting from an increase in the degree of activity generated within the Greenbelt. Fundamental aim of the Greenbelt is to prevent urban sprawl, keep land permanently open. It's got a visual and spatial quality, as we know. From a spatial perspective, the proposed arrays would introduce substantial development into the area in terms of ground cover due to the quantity of arrays within the scheme. Of course, there'd be the associated access, tracks, substation, inverters, fencing, CCT, etc. And they'd all result in additional built form that would further diminish the openness of the Greenbelt spatially. But nevertheless, as Mr. Mason, Mr. Hoyle explained, the proposed arrays would be relatively modest in mass and footprint. They'd be spaced out at regular intervals, and that would reduce the overall scale of development. And the scheme would be in place for a temporary 40-year period, would then be fully demounted, and land returned to its former condition at the end of its use. So it's 40 years. That is a long period of time, but it's not permanent. And taking the same line really as the council, in planning terms, that is a temporary land use because it is temporally limited. Therefore, the impact on the openness of the Greenbelt would be reduced with the site ultimately reinstated to its former open character. Consequently, both spatially and visually, the proposed development would result in limited and temporary harm to openness of the Greenbelt. Purposes, paragraph 138 defines the 5 key purposes, with some disagreement between the historic view of Mr. Griffiths and the other planning witnesses between the original purpose of the Metropolitan Greenbelt. And should I just say, I don't want to be any discourtesy to Mr. Griffiths. When I referred to locals sort of impassioned without professional qualification, of course, that excludes Mr. Griffiths, absolutely, who gave very interesting evidence. But I disagree with his view in relation to the original purpose of the, well, not disagree with the original purpose, but I think things have moved on, and prefer, on behalf of the applicant, the view of the council and Mr. Hoyle. The applicant's view is that development would not result in the extension of a large built-up area, and given the distance and limited intervisibility from surrounding towns and villages, it wouldn't conflict with the purpose of restraining unrestricted sprawl. There'd be no diminution of the purpose to prevent neighbouring towns from merging with each other. So accordingly, we say the development would accord with the first two purposes. The action is really about purpose 3. Or purpose C. Mr. Hall readily accepts the proposed development would introduce built development into a countryside location. Now the site adjoins the A1M. It's in an area which is already degraded by urbanising influences. I was interested, my ears pricked up, I think, when Mr. Harding described the A1M as a legitimate purpose in the Greenbelt. Thought that was interesting. It's his paragraph 16. The motorway is a legitimate use of land within the Greenbelt. Not quite sure what that means, because of course lawful for solar farms in the Greenbelt passes planning tests, that would be legitimate too. The purpose or the point is that the A1 is a large scale urbanizing influence and characterizes the corridor through which it passes. The proposed development is of low height, which sit within the landscape framework such that once the proposed mitigation planting is established, the proposed development would not be intrusive and an appreciation of the landscape as countryside would still be possible. And I think it's important just in relation to the A1, because Mr. Harding suggested that that view from the A1 was almost the most important view to give an indication of what was good about this part of Hertfordshire. And he referenced the 30 million people that pass up and down. Having gone on the motorway past the site every day, and as you'll see this afternoon, actually, given the elevation of the A1, that sense of openness will absolutely persist. So I think you absolutely encourage you to go on the motorway as you will this afternoon, but far from that being a negative point. If that is what Jog is concerned about, actually, I think that is an example of how an appreciation of the landscape and the openness of the countryside would still pervade. So, yeah, the proposed development would introduce built development to a countryside location, but having regard to the site's context and surrounding urbanising features, the nature of the development and the mitigation proposed harm in terms of encroachment would be limited. And the final two purposes we say aren't relevant. So other harm then, landscape and visual, somewhat unusually for a commercial scale solar farm inquiry, there's a high degree of agreement between the applicant and the council. Following consultation responses prepared by TLP, the independent landscape consultants appointed to work on behalf of the council, a response document was prepared, that's CD 33 as you know, which set out some additional mitigation measures. Mr. Mason was open in saying the applicant was grateful to TLP for what he considered to be improvements to the scheme. The applicant listened and it built in, was asked to do things and it's done that. And I think that has resulted in a better scheme. Introduction of the proposed development would increase the influence of built development across the site, result in a moderate adverse effect. However, the pattern of vegetation covering the landscape around the site is such that existing tree belts and hedgerows would provide considerable screening, greatly reducing the overall extent over which the proposed development would be perceived as a new landscape characteristic. The effect on landscape character would not be substantial beyond the site boundary, with a moderate to minor adverse effect which would not be significant. And as Mr. Mason indicated, it's reasonable to conclude, therefore, that landscape harm would be limited. There'd be limited visibility of the proposed development due to its low height, existing screening, the influence of landform. Indeed, the visual containment, we say, is highly unusual for a scheme of this size. In the short term, major to moderate adverse visual effects would occur from parts of the Hertfordshire Way, along the northern boundary of the northern part of the site, and from part of Gravely Lane, which passes between the northern and southern parts of the site. From each of those routes, the adverse visual effects relate to where there are gaps in the existing boundary vegetation. In the long term, once the proposed mitigation planting is established, the visual effects would reduce and would be no greater than moderate adverse from a limited number of locations in close proximity to the site. Therefore, again, we say it's reasonable to conclude that visual harm is limited. By reference to a single photograph, which was taken from a contrived location and which was so zoomed in that it bears no relation to what the human eye would perceive, Mr. Griffiths on behalf of JOG sought to argue that there would be an unacceptable impact on the AONB. The site visit, so we say, will have clearly demonstrated that such an assertion is untenable. I think what it does do, and it's often important to look at calibration, or what I'm going to term calibration. That is how sensitive a party is to change. And, you know, in a case like this, aren't these silver bullets? This is about judgments, and it's about sensitivities and you know, drawing a balance. And, you know, if JOG is seriously saying that there is an unacceptable impact on the AONB from that viewpoint, which it was and persists with, then I think that helps to calibrate the case that it's making. The fact that you might be able to see in the distance, you know, straining to see a solar farm does not make that an unacceptable impact on the AONB or on its setting. And I think that's quite telling as a sort of window into the mindset of JOG and how it perceives change would, you know, whether it would be unacceptable or not. Also, it's not really come up, but there'd be no adverse, effect on the AONB, nor would it compromise any attempt to extend the boundaries of the AONB if that's what happens. Long distance footpath crossing the study area largely outside the ZTV in the Hertfordshire Way, whilst effective for a short length as it passes the east edge of the site, is otherwise not going to experience many views of the solar farm. No physical obstructions to the public right-of-way network, no evidence of deterrence has been produced by JOG. And so there are public rights-of-way in virtually every solar farm. The ones that are consented, the ones in the appeal decisions that you see, they all, because the countryside is crisscrossed with rights-of-way, bridleways, promoted routes and so on. So there's nothing unusual about having rights-of-way. And in those other cases, inspectors and the Secretary of State have been able to say, yeah, be a change, but actually that with suitable mitigation, the impact will not be unacceptable. The permissive paths proposed will enhance access to the countryside for local people, which is a significant benefit in the planning balance. And there's a sort of late point raised by Mr. Harding. He said he'd got a parishioner that had come in last night to say, look, we're very concerned, female joggers. And that, you know, when you read that, of course, that sort of thing has to be taken seriously, but it doesn't stand up to scrutiny that female joggers that are happy to go out into the countryside now would somehow feel less safe by reason of planting and CCT surveillance on footpaths. If anything, they're going to be more secure. And my respectful submission is that once, yes, that's an easy point to make about change, but once the scheme is there and the change has been made, that actually those paths will be used in exactly the same way and enjoyed for the purposes that they currently are. So for that reason, we say NE2, there's no breach of it, and the scheme would accord with it. So heritage, passionate and widely read as he was, I mean, the truth is that little of what Mr. Jackson had to say was helpful to the decision maker. It was interesting to listen to, but not terribly useful in terms of decision making. By way of contrast, the evidence presented by Miss Roy was calm, it was clear, and was to be preferred. As she explained, the submitted HIA considered appropriate desk-based sources. It included identification of all known remains recorded in the Hertfordshire HER, as well as identification of previously unknown remains through analysis of LiDAR data. The putative course of Roman roads in the vicinity of the site was identified. Paragraph 194 of the framework, the level of detail should be proportionate to the asset's importance and no more than is sufficient to understand the potential impact of the proposal. The HI identified a high potential for remains of prehistoric Roman and medieval date. As per the criteria of Appendix 1 of the report, high potential was considered to apply where the available evidence suggested a high likelihood of past activity within the site and strong potential for the archaeological evidence to survive intact or reasonably intact. So in recognition of the high but uncertain potential, the HIA recommended that non-intrusive geophysical survey be undertaken in the first instance to better define the archaeological potential. The gradiometer survey carried out by experienced staff from AOC's geophysical survey team, prepared by Dr. Kate Armstrong, who's an experienced geophysicist and an acknowledged expert in the field of geophysics, with an established international academic reputation for the development of solutions for survey in a wide range of environments. And that survey was undertaken in accordance with recommended good practice as specified by Historic England and CIPHER. As the interpreted geophysical results show, survey identified 3 concentration of anomalies of archaeological origin, 2 smaller ones in the northwest and southeast of the survey area, covering roughly 1 hectare each, and a more substantial group in the central eastern part of the survey, which covers approximately 8 hectares. All those 3 anomaly groups potentially date from later prehistory through to the medieval period on the basis of their spatial arrangement. One of the points that Ms. Roy made was that the clarity of the results and the variety of features that can be identified within them lent confidence to the results, especially the conclusions that they're unlikely to be substantial features of archaeological interest, aside from those mentioned that have not been detected. So, recognising the Geophysical Service has successfully re-identified a range of archaeological anomalies, 3 archaeologically sensitive areas have been defined, including a 12-metre buffer around the extent of those anomalies. The design of the development within the archaeologically sensitive areas will be achieved via no-dig solutions, which have been secured by condition. And following the discussion this morning, sir, I'm very happy if that is brought out in a specific condition to reinforce the importance of that, all to the good. For the avoidance of doubt, the no-dig solutions would avoid requirements to bury cable below ground. That would be reflected in an updated WSI. As noted in the evidence of Mr. Jackson, the interpretation of archaeological features can be complex and can change based on discoveries and research. Part B of LDP Policy HE4 requires a developer to demonstrate how archaeological remains will be preserved and incorporated into the layout of that development, if in situ preservation of important archaeological remains is considered preferable. Preservation of the identified remains is considered preferable, and indeed preserving these remains in situ will allow us to preserve them for future generations and future investigations. Where hitherto unknown remains are concerned, the provision detailed in the WSI for a 3% evaluation outside of the 3 archaeological sensitive areas would provide a means of ensuring preservation in situ or by record as appropriate of any significant buried remains thus identified. Section 4 of the HIA, subtitled Setting, outlines how setting and harm is considered for the purposes of the application. No formally prescribed method for the assessment of impacts on historic assets due to change in their settings, but published good practice guidance from Historic England forms the basis for the approach that Miss Roy had followed. Now, the Historic England Guidance GPA 3 document on setting explains how to apply the policies contained in the framework and the associated PPG. I don't need to read out the quotes. Assessments of changes to setting should focus on significance. Ms. Roy's approach to the assessment of change to setting of an asset has been focused around whether such a change would reduce significance, that is, result in harm. And crucially, as per the definitions provided in the Conservation Principles document, harm should be defined as a change for the worse. As per the PPG, what matters in establishing whether harm is substantial or not relates to whether a change would seriously adversely affect those attributes or elements of a designated asset that contribute to or give it its significance. Further, within each category of harm, the extent of harm may vary and should be clearly articulated. I think just breaking off there, I take the point too that Miss Daly made, that there was that off-the-cuff remark about substantial harm. That might sound okay to a sort of untrained local resident, even if they be interested, but substantial harm is really something of very serious gravity in relation to impact on significance. And as you know, sir, that can be right up to the point of being akin to total loss. That simply is not tenable in relation to what we are dealing with here. And again, that goes to that difference between interested local resident, passionate local resident, and a more sober professional assessment. So Miss Roy, there's a scale of 1 to 10, and her assessment of predicted impacts on the cultural significance of designated assets is set out in a proof and expressed in terms of the policy test on harm outlined in paragraph 202 of the framework. As per the recommendation in the Historic England Setting Guidance, a ZTV that took into account landscape artifacts such as trees, woodland and buildings is preferred. Core document 107 clearly demonstrates how visibility of the proposed development, limited across the landscape and specifically from the majority of the designated assets located within 2 kilometres of the site. ZTV very helpful in demonstrating the limited visibility from the Great Wymondley Conservation Area. The conservation area character statement for Great Wymondley, I think that's CD 93, identifies key views and character photographs. None of those would feature or be impacted by the proposed development. There'll be limited visibility of the proposed development from the churchyard of the Grade 2 star listed St Mary's Church. Similarly, limited visibility from the grounds of Wymondley Priory, no visibility from Gravely. Of course, it's not just about visibility. Accordingly, the HIA, Miss Roy's evidence carefully considered the historic landholding relationships between the site and the surrounding designated assets. That resulted in identification of less than substantial harm to the Gravely Farm assets and the Great Wymondley Conservation Area, owing to their historically documented relationships, despite the fact that they would have little or no visibility of the proposed development. And if I could just break off there, you've got the Manuden decision in the core documents. There was another scheme adjacent to the Manuden scheme called the Pelhams scheme, with which I was involved, and there was a legal challenge brought there on the basis of a failure to recognise relationships in an historic sense between buildings and land. So the purpose of that paragraph is just to reinforce that any assessment of significance isn't just about visibility. So historical connections and the relationships between buildings and their hinterland absolutely does go to questions of significance. And we've dealt with that. Mrs. Roy was clear in having dealt with that. So Mr. Roy's assessment of less than substantial harm, largely in agreement with the conclusions of Historic England and the Council. Moreover, the less than substantial harm that is identified is at the lower end of that scale in each case and should be weighed against public benefits. Next, I turn to ecology. Subject to the imposition of appropriate condition, no nature-focused consortia organisation has objected to the application or raised substantive concerns over the development. Hertfordshire Leeds has considered the application twice, including the latest BNG calculations, most recently on the 15th of September, and it didn't object. Natural England hasn't objected, and following modest revisions to the landscape scheme, the Hertfordshire Middlesex Wildlife Trust didn't object either. The Council's committee report concluded that, subject to the imposition of recommended conditions, the proposed development wouldn't result in harm to biodiversity, and that on balance there would be net gains which weigh in favour of the granting of planning permission. And I can just add there that those conditions set out in that letter of the 15th are now incorporated in the conditions. We've dealt with that this morning. There's that tightening up in relation to monitoring for hares and so on, but all of those conditions are in play. The application site provides limited ecological value overall. What does exist is almost all restricted to boundary features, which will be retained. The application site is a modern arable farm typical of the region, comprises large open arable fields bounded mainly by hedgerows. Some of the field margins are managed for wildlife under the government's CSS agri-environment scheme. The current environmental ecological value of the application site is almost exclusively in hedgerows, woodland and managed field margins. The open fields themselves offer very little by the way of refuge or food for wildlife and are intensively managed for food production, including the use of agricultural chemicals. A large majority of the application site is effectively sterilised for most wildlife through agricultural practice. As Mr. Fern gave evidence, the EAR was undertaken in accordance with best practice. Its conclusions are accurate. It was completed by suitably qualified and competent professionals and in accordance with best practice standards, including the British Standard. The EAR identified key habitats and the presence or likely presence of protected and notable species, along with the proximity to statutorily designated sites for nature conservation. Field survey data was then used to aid the design of the proposed development, with the resultant layout avoiding hedgerows and woodland and incorporating wide 12-metre field margins. As a result, even before any habitat creation is considered, the proposed development avoids impacts on the most valuable habitats and associated protected and notable species. The scheme wouldn't adversely affect any statutorily designated sites. Temporary impacts on the Wymondley local wildlife site could not be avoided because the substation connection is entirely within the LWS, but they'll be limited to the digging of a temporary trench with subsequent reinstatement. As with all developments, there will be impact on some species. Largely, these will be limited to the construction phase. However, standard good practice measures secured by planning conditions will ensure legislative and policy compliance and minimise effects. Once construction is completed, populations of these temporarily impacted species will recover, and with the habitat creation implemented, can be expected to strengthen. Planning application included landscape proposals, which mean the scheme will include substantial areas of habitat creation and enhancement, particular new areas of grassland, native species, woodland and hedgerows. Those habitats will be of ecological value, the application site for a large number of species, and further strengthen ecological connectivity with the wider landscape. The cessation of the use of chemical application for crop production, highly relevant. Agricultural chemicals are a major source of invertebrate decline, and so simply by stopping use of chemicals, there'll be benefits to the wider ecosystem. Inevitably, those few bird species which rely on open fields will be unable to persist within the application site. Such species are, of course, entirely dependent on the cropping regime in any one year and can be lost where markets dictate other priorities. The applicant has agreed to the delivery of a skylark mitigation plan, which will ensure the local population of this species is secured for at least the next 30 years. The highest that Mrs. Hamilton could put it was that she'd got concerns about the creation of skylark plots, whether that would be effective. Mr. Fern doesn't agree. He indicated it's standard practice, it's supported by the RSPB, and DEFRA continues to encourage their use. The Fox paper, relied on by Mrs. Hamilton, also includes evidence of the success of such plots, amongst others. The condition requires a scheme for mitigation to be submitted to the council for approval in writing. JOG will be invited to take part in the consultation process. And so that Crays Hall Farm decision gives you comfort that that can be done by way of condition. You'll recall that there was the Manyaden scheme. Mrs. Hamilton referred to the Manyaden scheme and saying that skylarks there were a cause of the refusal. It was a very simple point. The applicant had said there needed to be mitigation and they hadn't provided a section 106. So that case doesn't take the argument any further than that. In relation to bats, Mrs. Hamilton relied very heavily on the recently published Tinsley paper from July 23. That's an initial research paper, which is suggesting that more work needs to be done to understand the potential impact of large-scale solar farms on foraging bat. It isn't policy and doesn't purport to set out development management considerations. And again, I think there's just an interesting point to break up, because you recall that interchange with Mrs. Hamilton about what was policy and what wasn't. And in her mind, Mrs. Hamilton couldn't understand why that preliminary research paper wasn't policy. And again, I think that just is a window into the mindset, because Mrs. Hamilton was, clearly the view, she's passionate about biodiversity. She just thinks that nature isn't being taken care of in a bigger sense, and that nature and biodiversity concerns aren't being listened to. And that leads her to go, well, if there's a bit of research that helps that supports my view, that should be policy, we should follow it. Unfortunately, that isn't the way that the planning system works. It isn't policy, it is interesting. And I think that she was actually misreading both the substance of that report and the weight that should be placed on it. It was, I think, also wrong of her to suggest that paper on its face concluded that solar farms have been shown to have an adverse impact on the conservation status of bats in general, let alone a particular type. What the authors noted was a reduction in foraging activity over solar arrays for certain types of bats. And you recall when she gave her evidence in chief, I questioned her on this. She said the paper said that was about harm to species. It wasn't. What the authors were noting was a reduction in activity over solar arrays for certain types of bats. What the authors did suggest was that, look, where necessary, mitigation to support bats should be designed and activities should be monitored over extended periods. Mitigation may include, but not limited to, reducing the density of panels, ensuring boundary habitat is maintained and improved in its area and diversity, ensuring appropriate planning to improve foraging resources. Well, that's exactly what the proposed development does. It ensures that boundary habitat, hedgerows and linear planting is maintained and improved. So the Tinsley paper, we say, provides no justification for refusal of planning permission. To help demonstrate the impacts of the proposed development, the application includes the biodiversity gain BNG calculation using the recently developed metric version 4. calculations, so a very substantial BNG increase, which far exceeds the requirements of both local policy and the NPPF. Gains also substantially above that, which is coming out for the 10% statutory requirement for November 23 under the Environment Act of 2021. As such, it's clear the application accords with relevant local and national policy. Mrs. Hamilton made a point plain. She said, look, I don't like the fact this is being quantified. I don't like it's being objectivized and metricated, but that's the policy. And that's going to be law. So that is the framework within which we are working. Accordingly, the proposed development will be beneficial for habitats, a large majority of species, both within the application site and the wider locale. Where objections to the proposed development on ecological grounds being received, largely express concerns that wildlife populations will suffer or that movements will be restricted due to fencing. The latter issue, commonly addressed through the installation of mammal gates in security fencing, they're referenced in paragraph 7.7.21 of the EAR. In terms of wildlife populations, the literature submitted by Mrs. Hamilton only served to demonstrate the consensus that solar farms provide an opportunity for ecological enhancement. And I think when we went through those documents, there was the cross-examination in relation to the Montague paper. And I mean, it struck me, I'm not quite sure of the point that Mrs. Hamilton was making in relation to that paper, because read objectively, I think it's difficult to rationally conclude that any other way, that the Montague paper said you were going to get biodiversity enhancement from solar farms with the potential exception of skylarks. But in relation to broadleaf plants, grass, invertebrates, butterflies, bees, birds, solar farms were seen to be resulting in improvement. We say that's unsurprising, as by and large wildlife is not concerned about aesthetics. They don't care what solar farm looks like. They require shelter, food resources. So both of those will be approved at the application site for a large majority of species. So in terms of policy compliance, we say it complies with the local plan policies and the relevant paragraphs in the NPPF. Transport, full agreement between the council, the applicant, Herts County Council, the council regarding traffic. Mr. Kendall was involved in discussing the scheme with the county council at an early stage, considering the transport implications from the middle of 2022. His team oversaw production of the transport statement. A number of matters were agreed, including relocation of the northern site access junction slightly to the east, formation of a passing place on Gravely Lane, technical points on the level of visibility displays that should be achieved from and towards the site accesses, and revised swept path assessment plans to demonstrate how the site can be safely accessed. Construction is the most onerous phase for a solar farm in traffic terms and will last around 36 weeks. And as Mr. Kendall explained, in the first 4 weeks, there'd be 40 two-way HGVs plus 120 two-way light vehicles, that being staff per day. Volumetrically, that's equal to 1 additional vehicle movement every 4 minutes or so on average, and that would be imperceptible. In the following 32 weeks, 8 HGVs plus a maximum of up to 120 two-way light vehicles, again, staff movements per day. And the operational phase likely to be in the order of 1 to 2 visits per week in a light vehicle by a maintenance engineer on average. The decommissioning phase would mirror the construction phase, but with traffic more evenly spread out. There are robust assumptions based on 2 staff per vehicle. In reality, likely to be more staff per vehicle, so there would be less staff traffic. Single passing place located along the slightly narrower section of Gravely Lane, just east of the northern site access, big enough to allow 2 HGVs to pass. That measure's not needed elsewhere as the road's wide enough for 2 HGVs. Scheme also includes construction of 2 junction bell mouths at or adjacent to existing field access points to safely and satisfactorily accommodate the modest development-related traffic. Passing place would be removed following construction and reinstated as a verge, stroke natural habitat. Geometry of the site accesses will be reduced to resemble the existing agricultural accesses, and a banksman would assist with deliveries at the accesses. Construction activity limited to conventional working hours that protect amenity, notwithstanding that we said there'd be no material sensitive receptors along the route. All deliveries and HGVs would be routed via the A1M junction 9, via the A505, the B197, Gravely Lane. That route avoids sensitive receptors in local settlements and congested areas. Perhaps the most disruption would be experienced during installation of the cable route, but the roadworks will be phased. Each phase will be much shorter than construction on the main site, perhaps 1 or 2 weeks for each phase. They'll be agreed as part of a separate consenting regime to planning, Section 50 licence with the Highways Authority, as is the normal procedure for roadworks and laying of services. Diversions and suitable traffic management will be in place. In relation to harm to Greenbelt, bearing in mind the limited traffic generation, mitigation measures proposed, temporary nature, and proposed controls that say would be very limited. Indeed, the council go a little bit further. They say that transport harm would be neutral in the planning balance. Concerns with the local community are understood, but our view is that they're unwarranted. In response to the assertion the local roads are busy, it wasn't really supported by the evidence. The submitted transport statement indicated the result of automatic traffic count surveys along Gravely Lane, which is, of course, the only part of the local road network at the periphery of the village that could conceivably be materially affected. That demonstrated on average peak hour baseline traffic flows along Gravely Lane are much lower than the actual road carrying capacity at around 4 to 5 movements per minute on average. The development's not going to add materially to that. Most construction traffic would take place outside the peaks anyway. Implications flowing from the laying of an electricity cable wouldn't justify refusal of planning permission. In terms of operational traffic, varies slightly throughout the year as the maintenance demands of the site change throughout the seasons. But nevertheless, based on the operational experience of the applicant, the site will likely generate 1 to 2 light vehicle movements per week on average, probably no more than 1 to 2 movements per day at peak times. So as such, the level of operational traffic would be imperceptible, particularly in view of the movements that could otherwise occur under the site's existing agricultural use and the farm traffic that would otherwise take place. Agricultural land. So grades 2 and grades 3A, 32% the former, 68% the latter, and as a result is classified as BMV. So temporary form of development, the majority of the land beneath the solar panels would remain in agricultural use through sheep grazing for the 40-year operational life of the solar farm. After that would be returned to agricultural use following decommission. It's also recognised in the appeal decisions referenced above that removing land from intensive agricultural use for the life of the solar farm would improve soil health by increasing the organic matter in the soil and improving soil structure and drainage. It's not going to be permanently lost. Agricultural activities would continue throughout the operational period. Full agricultural use could be recommenced following decommissioning. There may be some limited harm associated with the temporary loss of versatility and function, but there'll be long-term benefits to soil health, soil structure, and carbon sequestration. So overall, the applicant considers there to be no harm to BMV. Recent development management decisions are concerned there's no planning policy reason to refuse development because of the reduced flexibility of the land for food production during the operation of the solar farm. Council have accorded moderate weight to the reduced food production consequence, although that's now been downrated. So I noticed in the council's submissions that I think, having heard what Mr. Kernan had to say, the council is convinced in relation to that. So we say very limited weight should be accorded to food production issues. As a matter of principle, matter of analysis, there's no planning policy to require land to be used for food production. There is no food security crisis or concern. Government funds arable land conversion to grassland. It's clearly not seeking increased food production as a consequence. The actual implications of retaining the site for food production are minuscule, 119 tonnes per annum from national production of 24 million tonnes of cereal. The benefits in terms of carbon sequestration, organic matter, reduced erosion, reduced compaction, and improved biodiversity are substantial. Mr. Kernan is a highly respected expert in this field. Indeed, some may say preeminent. He gave clear evidence that he saw no reason why the agricultural land couldn't return to high quality production upon restoration. And no evidence was produced by Mr. Griffiths on behalf of JOG to the contrary. It was floated somehow that this wasn't going to return to high quality production. Well, Mr. Kern's the expert. He says, no, absolutely it can. So there are no reasons, we say, based on what Mr. Kernan had to say, based on agricultural reasons, to refuse permission. Flood risk. Complete agreement between the applicant council and the LLFA. Submitted FRA assess the risk of flooding to the site from all known potential sources. The assessment concluded the main part of the site not at risk of flooding from the sea and from rivers, isn't at risk from reservoirs or from canals. It's at a negligible risk of flooding from groundwater and is overall at a low to very low risk of surface water flooding. The assessment indicated the presence of 4 overland flow pathways across the site, 2 across the northern part of the site, 2 across the southern part. Detailed hydraulic modelling confirmed the presence of these pathways in the 1 to 30 event and greater, and that the maximum depth of flooding for all pathways and events was less than 100 millimetres, even during the 1 in 100 event, plus climate change. On a walkover survey, Dr. Silford was unable to identify any defined flow pathways on the site, with the exception of the one located in the northwest corner of the northern part of the site, which correlates with a defined valley across the site. In reality, though, the runoff is actually conveyed below ground in a pipe. The panels, the inverter transformer containers, the storage building, the control building and battery storage containers are all raised above ground. You, being eagle-eyed, sir, noticed that the single switchgear building isn't raised, but that is not located on a defined overland flow pathway. So as such, the overland flow pathways would be unobstructed. Surface water runoff would be able to pass freely beneath. In the no-dig areas, concrete sleds which run perpendicular to the panels would not impede flow. The assessment also confirmed that part of the grid connection route, 700-metre length along Stevenage Road, is located in land indicated to be at high risk from flooding from Ashbrook in flood zone 3. The assessment confirmed the cable installation works wouldn't increase flood risk elsewhere because the cables would be laid within narrow trenches located in the highway, and that relatively short extents of trenches would be excavated, with reinstatement generally occurring within a week. It's agreed that no spoil would be stored along Stevenage Road or along Priory Lane. Again, that's going to be prioritised in a condition. This forms the subject of a separate note and secured by specific mention in the condition, so that can be now in a specific standalone condition. Accordingly, the proposals accommodate overland flow across the main part of the site. The cable installation process wouldn't increase the risk of flooding, and the proposals would be safe from flood risk. In relation to concerns raised by local residents, the principal source of flooding is Ashbrook, drains an area of approximately 14 square kilometres, 2 kilometres of that catchment comprising land to the northeast of Little Wymondley, including the site, subcatchment drained by an unnamed watercourse often referred to as Priory Lane Stream. To provide context, the site itself constitutes approximately 5% of the Ashbrook catchment drain to Little Wymondley. There's a history of flooding, and I set out the dates for that. Following the 2014 flood event, the County Council, as LFA, undertook an investigation into flooding as required by Section 19 of the 2010 Act. The findings of that investigation were reported in the Section 19 report. That stated the catchment responds quickly to heavy and prolonged rainfall because the catchment comprises of clay, which permits minimal infiltration. The flooding was caused by a combination of heavy rainfall in 6th or 7th of February of that year and a series of storms. It identified a number of factors contributing to flooding. They were blocked trash screens, blocked culverts, undersized culverts, blocked road gullies, overgrown and heavily silted open channels, runoff from fields, agricultural field drains, soil compaction due to farm machinery, ploughing of fields, vehicle bow waves and unmaintained water meadows at Corey's Mill. A number of recommendations were made. There wouldn't appear to be any simple course of action that would reduce the probability and impact of flooding to Little Wymondley. The potential for a flood alleviation scheme is limited due to the confined nature of the watercourses and cost-benefit viability. As a result of that, the County Council commissioned a consultant to investigate the feasibility of options to alleviate flooding. They reported in 2015, generally consistent with the Section 19 report. In respect to Priory Lane, the report stated that the drainage network is inadequate, undersized, resulting in floodwater being routed along Priory Lane, but it was infeasible to provide a flood alleviation arterial drainage type scheme that would prevent flooding of the village up to the typical design, which would be the 1 in 100 plus climate change rainfall event. So all of that, against all of that background, far from worsening the situation, the proposed event would contribute to a reduction in off-site flood risk. Published peer-reviewed research has shown that solar farms have a negligible effect on the hydrologic response, that is runoff rates and volumes, if the pre-panelled and panel sites comprise of grassland, but that runoff rates and volumes could increase significantly if the panel site comprised of bare earth. Of course, in this case, the opposite is true. The site's currently bare earth for a significant part of the year, whilst the panel site will comprise grassland. So that would be expected to significantly reduce peak runoff rates from the site on its own. But in addition to that, the applicants developed a belt and braces approach. There are 3 surface-based flood storage basins proposed to store runoff from the panel part of the site. 3 surface water attenuation, should be attenuation, not attention. 3 surface water attenuation basins proposed to attenuate runoff from the access tracks and compounds. Rainfall infiltrating into the access tracks and hard standing areas would be conveyed to Priory Lane stream or to existing drainage ditches. Infiltration testing has confirmed that it would not be feasible to dispose of surface water runoff to the ground, so this approach complies with the drainage hierarchy set out in paragraph 56 of the Flood Risk and Coastal Change section of the Planning Practice Guidance. That's at CD 64. The attenuation basins would store runoff with the outflow restricted by outlet control devices. Overland flow generated from the panel part of the site will be intercepted and stored in the flood storage basins. Runoff released from the basins at a controlled rate to the receptors referenced above. That's a conservative approach, and it would reduce peak runoff from the site by 14% for the present day, 1 in 30 AEP event, 3.5 to 5% for larger events, assuming the site comprises grassland both prior to and after development. Of course, in reality, the betterment would be higher than that because the site's bare earth for part of the year. We can't solve everything. So whilst the drainage and overland flow management will not eliminate downstream flooding, the proposals will reduce the peak runoff rates from the main site, thereby reducing peak flood flows in the Priory Lane stream, along Priory Lane, and hence in Little Wymondley. And I think the villages accept that as a benefit. We say it should be given more credit than it is, but everyone in the room is saying that is a good thing. So in relation to policy, I can summarize paragraphs 470 and 471 in saying that we comply with both of those. Benefits. These are the same list of benefits that I set out in opening. They relate to the significant need to get on with reducing carbon emissions, wider environmental benefits, reversibility, and so on. So I'm not going to read those out. Consistency with policies on climate change and flooding. This is really bringing the points together. And I say chapter 14, paragraph 155 are relevant. And paragraph 155 we looked at, of course, there was the change in the September the 5th version. And there was that interesting question which you raised, if you recall, about the wording in 155A, where there was the use of the word appropriate. Yes. However, that is in the, I mean, who knows why that is in there. There is an inconsistency between, requiring local councils to bring forward policies which refer to appropriate and a development management decision where they have to be, where you should get your consent if the effects are or can be made acceptable. And in our case, this is obviously a development management decision. Interesting why that's changed, but the development management decision principles in 155 haven't changed. So we say that's the relevant test that you should recommend that the Secretary of State applies, and we say that we comply. Consistency with policies for conserving and enhancing the natural environment. I set out the relevant paragraphs there and bringing together really all the points that I've already made. I'm not going to read that out. Consistency with development plan for the area. The lead issue in this case is compliance with Greenbelt policy and whether harm caused by reason of inappropriateness and other harm is clearly outweighed. Policy SP5 states the council supports the principle of the Greenbelt will only permit developments in Greenbelt where they wouldn't result in inappropriate development or where VSCs have been demonstrated. That's reflective of policy at the NPPF level anyway. Policy NE12 relates to renewable or low carbon energy, and we say that we comply with that. And I think these are all just repeating really, but bringing together points for the benefit of the Secretary of State that I have already made. So I'm going to turn then to section 5, concluding remarks. The proposed development will be situated in the Greenbelt in a clear and compelling way. The applicants demonstrated that there are no suitable non-Greenbelt alternatives and why the point of connection has to be at Wymondley GSP. Once that narrative is accepted, then the planning question becomes one of balancing harm against benefits in the normal way. And as the applicants demonstrated, the harm caused by reason of inappropriateness together with other harm relating to all those impacts I've just gone through, landscape and visual, heritage, ecology, highways, flood risk and use of B&V land would be clearly outweighed. As a result of that, the proposed development would comply with national policy contained in Chapter 13 and thereby comply with relevant policies in the adopted development plan dealing with Greenbelt. With regard to those other considerations, would assist in delivering the need for renewable energy development in the context of the legally binding net zero targets established by the Climate Change Act 2008 and other various instruments and policy objectives that you've got in front of you. It's a very ambitious sub-target for decarbonising the electricity system by 2035 that's been announced by government. National Grid's ESA future energy scenarios and associated data make it very clear the development of solar PV and other renewable energy sources needs to be accelerated to achieve the net zero target by 2050. And just going back to a point I made about Rishi Sunak, he's not walking away from net zero attainment by 2050, far from it. He's saying absolutely we'll meet that. Well, to do that, you have to come good on all of those generational requirements. And this is one of those projects. The Climate Change Committee report to Parliament clearly sets out the UK is significantly off track to meet the government's target of 70 gigs by 2035. An average annual deployment rate of 4.3 gigs is required to deliver that 70 gigawatts of solar by 2035. Current deployment is significantly below this level. At a local level, North Hertfordshire only generates 10% or thereabouts of their energy requirements from renewable sources, and they haven't consented a commercial scale renewable energy project since 2015. And I think I say this to its great credit, elected members have done the right thing in this case, and they should be applauded for having done so. The council declared a climate emergency and is seeking to do something about it. So if the government's serious about its commitment to tackling the climate change emergency, actions required now to dramatically alter the current path of future greenhouse gas emissions within the district and nationally, that means actually getting solar farms built and not just talking about getting them built. As Mr. Collier spelled out, the proposed development is financially viable and can be brought forward well in advance of 2035 to start delivering the reductions in CO2 envisaged by legislation and national and local policy and strategy. And I think that's important because in some of that evidence that Mr. Collier gave about connection dates, you heard him say connection dates are now past 2030. They're into the early 2030s, and in some cases into, towards 2035 itself. So that means schemes, even if they're envisioned now, won't get built. They won't get built until into the next decade. Here you have a scheme which is deliverable, which is financially viable, and which will get built. And recent case law has demonstrated that deliverability can be a material consideration. That's the Newcastle City Council case. And absolutely, here it is, deliverability is a material consideration. This scheme is going to get built. And we say that that certainty of assisting in meeting all of those objectives is something that weight can be attached to. It's not a theoretical exercise. We're here for a reason. So based on the evidence it's called, the applicant respectfully requests that you, sir, recommend to the Secretary of State that planning permission should be granted in the form in which it has been sought. So those are my closing remarks on behalf of the applicant, and unless I can further assist, that's the end of our case.
Thank you, Mr. Hardy. Yes, I think there are 3 points I just want to check with you. First of all, paragraph 1.8. The second part of that paragraph, you refer to consent for a BESS scheme. I just want to be clear what's being talked about here, because one of the points that's been made several times is that the council hasn't granted consent for some time for a a solar scheme in North Herts.
That is not a solar scheme.
I just want to be clear about what the reference is to.
So my understanding is yes. So that is just a battery scheme. It isn't. There's no generation involved in that scheme.
So that's a battery scheme. Is that in the evidence?
That is in the evidence. That was in
okay.
Yeah.
Okay, thank you.
Point I'd make is that commercial scale generation, that rather, so battery obviously is not generation, that's helpful, but it's a facilitative thing rather than,
yeah,
that's the point.
And then paragraph 4.1, you start talking about the green belt. I think when you departed from your text, you made a reference to development which is appropriate in the green belt. Just one, it's perhaps a bit of a nitpicking point, but I think the reference is in policy to development which is not inappropriate rather than the development which is appropriate.
Absolutely right. It's not, it's development that is not inappropriate, yes, by definition, for definition purposes. I think by going off scheme, what I was, it was just a general point I was making, that appropriate seemed to be, or inappropriate seemed to be a suggestion, or there was might have been a suggestion that was, because they were not suitable or acceptable, yes, in the green belt. It is as you know, just a pure policy point in relation to those categories of development which are described as not inappropriate.
Oh yeah, 4.11. This was reference to the photograph put in by Jog. I think you were maintaining the suggestion that the Jog photograph was from the AONB. I think Jog in evidence had acknowledged that it was on the other side of the boundary and had already updated their position.
I don't think I suggested that it was from within the AONB.
Right, that was, but you departed from text again there, and that was the implication that I'd got.
What I was, well, that photograph is being relied on by Jog to demonstrate an impact on the AONB, unless I've misunderstood.
Right, okay.
So I absolutely, no, it was corrected to say, I think it was taken just the other side of the road.
It was, yes.
Yeah. No,
yes.
So outside the AONB, but nevertheless, that was still being relied on as evidence to demonstrate that there would be an unacceptable impact on the AONB. So no, I absolutely accept the clarification, but the points I make in 4.11 are still valid.
And I think, sorry, I said 3. I think this actually just one additional point concerning the views from the motorway, yes, which you made reference to, and I think gave a suggestion as to impact. Although I've been asked to go there and I've said I will, I don't think that there's been any evidence put directly about views from the motorway by any party.
Without doing a word search, of the application documents and Mr. Mason's, yes, proof, I can't.
It's certainly not been discussed at the inquiry.
That's absolutely right. All I would then say is that I would ask you to take some inspector's note. You'll form.
Oh yes,
you will form your.
I'll form a view, but exactly. I didn't want to hear views about the impact from the.
I don't know, unless I'm corrected. I don't know whether that's right or not. But I'm quite happy to accept that it has not formed, yes, the subject of debate in the chamber about impacts from the A1.
Thank you. Right, thank you, Mr. Hardy. That was all my points of clarification. One thing I've got to come back to now we're towards the end of the inquiry is whether there's any update in terms of cost applications.
Yes, there's no application for cost now.
Certain.
Good. And in terms of the individuals who've kindly consented to accompany me down the A1M, can I just check that you're, given that we've now passed 1 o'clock, are you happy to continue more or less straight right after I've got my?
Yeah. I mean, I've got my tank with me, so it may be appropriate to use that instead. Very eco-friendly one, though. Yeah, that's fine. That's fine. Yeah, yeah, we can go mine.
You're happy to carry on straight on for
fine.
sure.
Yeah,
Robinson? Yeah. Okay. Right, I'll probably need about 15 to 20 minutes just to pack up and arrange with the courier for my box. Mr. Greaves, when my box is ready, should I take it down to reception and just leave it with them? Had they been forewarned? So you'll do that, I reckon, and then, yeah, my box follows up. That will make sense. Thank you. Right, it's, I think we're at the end of proceedings. So I'd just like to thank everybody for the spirit in which the inquiry's been conducted. It's been very helpful and positive. In fact, I think the only awkward customers, if I can call them that, were the cattle that we encountered yesterday. So thank you all. The inquiry is now closed.
Thank you, sir.